60? Don't worry, we'll vacate the stay. Then we will jump and the client will. No, transfer has to finish. When the other side is appearing, matter is over. No consent business works out here. Ask your senior to be there. Next. Item number?
Not to be present today. So due to medical emergencies in his in-laws family.
It has come up for orders.
Yes, Lordship.
Where do you want to mention?
He's having some difficulty. He's having some difficulty. He's not in the
You
court.
appear. We'll see when the
Not in
matter is
court,
there.
Lordship.
Then none appears. Sorry. Yes, Mr. Naik, what do you have to say?
So far as the first part is concerned, that is payment of compensation. That on the last day itself, we have issued a check. And so far as second part is concerned, if Lordship comes to the affidavit filed by the ACC of 6/6/2025, I will page 231.
So you want to vacate by 31st August?
My lord, I have a problem regarding the check, my lord. The name of this check, some mistake is done here, my lord. His name is, bank name is Umesh Dekka, and Panda is not there, my lord. I am punishing to returning the check by making the correction, man. They are to first check. With the petition is there, my lord, but in the bank name, it is, Sando is not there.
That can be done.
So they will be vacating by August 2020. Stop.
So I think this matter may be closed, Lord.
Hmm?
Matter may be closed, I think.
No. After you vacate, because I have to then close that matter also.
Yes.
Because then only I can do it. Because otherwise, if I'm not interfering here, the criminal proceedings will start. So therefore, I have to close that matter also. Once you vacate, then I'll pass an order that in view of the vacating, no further proceedings be proceeded in that matter.
In that matter, Lordship,
We are
Lordship will take this matter.
We are, if the matter is solved here, my lord, we are also not interested.
But the problem is not that. Then it becomes between the court and the accused. So I have to close that matter. So if I close here, that matter doesn't get closed.
Yes.
That matter will only get closed when they vacate.
Then we ask to hand over first check, my lord.
Heard Mr. P. Naik, the learned counsel, appearing on behalf of the petitioners, and Mr. D.C.C. Fukon,
My lord.
the learned counsel, who appears on behalf of the respondent. Footstop. It is relevant to take note of that on 6/5/2025, a check bearing number, what is the number? Bearing number 279977 was issued favoring the respondent amounting to rupees 6,85,918. Full stop. Mr. DCC Fukon, the learned counsel appearing on behalf of the respondent, submits that though, give me that document. Mr. Fukon, give me the other one. No, no, not that one. That account number. Give me that only the account number. A check on Graduk. Submits that though the respondent's name is Umesh Chandra Deka, but his bank account is titled as Umesh Deka.
Right.
Under such circumstances, the check which was deposited was not accepted. He therefore submitted that the respondent, the petitioners be directed to issue a fresh check in the name of Umesh Deka. First, Mr. P. Nayak, appearing on behalf of the petitioners, submits that the said aspect can be duly, and that the petitioner shall duly take care of the said aspect and issue a fresh check in the name of Umesh Deka. First, Mr. DCC Fukon, during the course of the hearing, returned the check to Mr. P. Nayak. First, Mr. P. Nayak shall within 7 days from today provide a fresh check of the amount of rupees 6,85,918 drawn in the name of Umesh Deka and hand it over to Mr. DCC Fukon, comma. It is further seen that an additional affidavit has been filed, filed by the petitioners, wherein at paragraph number 4, comma, there is a specific undertaking given by the petitioners that the petitioners shall vacate the premises, the land, by 31st of August 2025. First, taking into account the said, comma, list this matter again on 3rd of September 2025 at the top of the list.
Hello.
You hand over the check.
Check on this.
What are you challenging?
Challenging lordship. For you. Challenging the in selection of the perfect respondent who are holding the grade of junior stenographer grade 3 and already just have completed 5 years. They have been given selection to the promotion to the post of grade 1 without considering the seniority of the petitioner held by this present petitioner.
You are grade 2.
In the field of grade 1, grade 3, we are serving since 2012 without having any promotion either to the stenographer grade 3.
So you are senior to the private respondents. And what is the policy for promotion?
Policy that has been so far the advertisement concerned.
Is it seniority come merit?
So far the advertisement is concerned, they have been given some criteria for selection. They who have secured 30 marks out of 50 will be eligible for consideration loss. Lordship will find the advertisement notification page 32.
You know, we issue notice and tag it with that matter.
This matter doesn't even merit notice.
Huh?
This matter is stenographer grade 3. Those matters petitioner were stenographer grade 2. Their concern was that their chances of promotion was limited.
No, Mr. MA6 matter. There are 2 matters.
I
One is
understand.
by Mr.
Yes.
P.K. Roy Chaudhary
I understand.
and the other is by, by Mr. MA6.
But here, his contention is that the promotion ought to have been given by virtue of seniority.
No seniority.
That is his only case.
No, Lordship, that part your Lordship, the so far there's condition in the advertisement, your Lordship. Minimum qualification they have prescribed. It is not the advertisement issue that only the marks basing on which they have obtained, they will be given selection. The cut-off mark given is 30.
Page 30.
For selection, 30 marks has to
What
be.
is the name of your petitioner? Manobendra Malakar and another. What is that? Where is his name? How much did you get?
42.
Huh?
Page 46, my lord.
Page Lordship will find.
Page 42,
6.
46,
Serial number 54 and 68.
54. You got 43.75 and 58 is 43.21.
No, 68, my lord.
68.
42.14.
So
One
they
is
say they have to be promoted by virtue of seniority, my lord. That was never in the advertisement.
42 and one is 54.
54. So you did not challenge the advertisement. How can you turn
No,
around?
Lordship, that is all, it is not that only basing of the highest mark which will obtain, that will given promotion. It is not the criteria of the advertisement, your Lordship. Who will secure highest mark,
Page 30.
they will be given only the preference for promotion. This is not a criteria. They have to obtain the qualifying mark of 30 marks. On the basis of that, the selection list was of this, your Lordship, made it this. So far the marks obtained by the all the candidates above 30, your Lordship, that was not. And it was not said who will obtain highest mark, he will be considered for promotion. This is not the advertisement criteria.
What is the purpose?
In absence of
holding
service
this
rule,
institution?
there is no service rule as yet, your Lord. In absence of service rule, executive has to be followed, your Lord.
Because page 32,
Why you are going into the SETI commission business?
Lordship, if suppose SETI commission is taken into consideration, 15-year service has to be completed by any of the candidate, either in the grade 2 stenographer. But as of 13 years of service, I have been completed. I have not given to the promotion even to the grade stenographer, grade 2, your Lordship.
No. But there is no post for grade 2 here. These are all grade 1.
Grade 1. It was grade 1 from amongst the grade 3 and the grade 2. It is not that only
But you are grade 3.
and grade 3. It is
So
from
what
only-
is your case?
Lordship, so
It
far
is
the
benefit
grade
only.
stenographer, grade 3 promotion means having 5 years experience will be considered for promotion from the grade 3 and the grade 2.
Then
And Lordship, even after that, I have been holding the post of grade 1, which has been already updated in the year 2015.
that
Without
that
any
is
promotion.
not a material consideration. What is a material consideration is you have to show me that it is seniority cum merit. That this is the threshold one has to get 50 marks or whatever may be. Then once you pass out this 25 or whatever the minimum marks, then it will be taken. That is the minimum. That is the seniority cum merit. But that is not the issue here. They are giving as per the seniority is being given on the basis of this. What do you call that? Where is that? Yes, this is being
Marks.
given on the basis of what these people have got. Surajit Kaur got 48. Then
Lordship, page 33 में काली
page
33,
36.
33,
33.
point number 5.
Point number 5. Yes, candidates securing more than 30 or more marks
50
will be eligible
for
to promotion for eligible. That will be the cutoff.
But the advertisement does not speak that the promotion will be considered based on the merit cum seniority. That has not been said. And in absence of the service rule, your Lordship, which is the executive order has to be followed, and these advertisements were issued based on the minutes of the meeting of 2022 or 18, your Lordship. Kindly have a seen, your Lordship, page.
Mr. Mohan, I know that.
So that
That is why I am taking it up in the other matter
Lordship.
where Mr. P.K. Roy Chaudhary has filed.
But
His
it-
case is this. There are 3 sets of litigation. This is the third one. The first litigation is pertaining to where these are grade 2 stenographers and they have been disregarded and grade 3 stenographers have been brought in. So there is a stay being granted in respect to those 6 persons who were from grade 3, isn't it?
Yes, yes. Ma'am.
That is one. Second petition is on the interpretation of these terms of the notification, completion of 5 years of service as stenographer of grade 2 or grade 3 in the district. The second case is for the purpose that he has to complete either in grade 2 or grade 3 5 years. That is the second case, if I remember.
Yes, yes, yes.
And the third case is what? No case.
No, Lordship, there is another, so far the other petition, they have been challenged the minutes of 2016. There are another minutes of 2018 mechanism.
I know that, you see, therefore I'm taking up that first matter. But remains everything. They have a particular, in these minutes, there is, which minutes you are referring to?
It's 65, your Lordship,
Page
65.
No, no,
65 is the Supreme Court judgment.
Last one is page 62, 61.
5, your Lordship, 55.
55 is the 2000, the earlier one. The latest one is not 61.
55 is the draft copy, your Lordship.
Yes, this is. This is a one-time thing which has been done. And out of here, only 6 persons have been given from who were from the grade 3. Isn't it?
Yes, yes.
I remember to that effect. So
Yes.
there were many persons who were from the grade 3. Can we see
Your
this?
Lordship, query, I have already paid all the grade 3, the candidates who are
6, na?
Oh, Lordship. Page, serial number, respondent number 4 to 15, Lord,
4 to?
15,
4 to 16.
15.
Yes.
They
Sorry.
have not been, there's appointment that has not been selling in other districts.
4, 5, 6, 6, 7. All these are grade 3.
Only
No, all are not grade 3.
only 2%.
All are not grade 3. There are grade 2
Grade
also,
two.
up to
2%,
16.
17 years old.
Surajit Kaur. Surajit Kaur is what?
Surajit Kaur is grade 3. He is the private respondent here. Serial number 1, 2, 5, 7, 9, 10, 11, 12, 13, 14, 15, and 17. They are made private respondents. They are all grade 3.
11 candidates.
And petitioners are also grade 3.
11.
Chalo. We should notice. Tag it with them. Why should we dismiss just before vacation at the main stage or more? We'll decide together all the 3. What has happened? Have you filed your affidavit?
I'm filing it by Monday, my lord. I have got the instructions.
When are
yesterday.
those matters?
26, my lord.
Oh. Okay, let us list it on 26th, this matter.
Fine.
Because on that day, I'll finish up those 2 along with this. List the matter on 26/6/2025.
Highly appreciated.
My pleasure. My lord, as per your lordship's order,
Hmm.
that is 6/6/25, we have filed a additional affidavit.
Hmm.
Stating almost all the dates, details. So in the additional affidavit, lordship may kindly see page 33.
You are challenging what, mister?
Order, we are challenging the impugned order. That is, my lord, 10/1/25.
What was the stage of the suit?
At the defendant's witness stage. And my lord, earlier it was allowed. Our petition was allowed to adduce official witness because my original cell deed has been lost and the witnesses who adduced their witness in the cell deed, they have died. So I filed petition to adduce official witness. That was earlier allowed. Kindly see page 50 of the additional petition. 50 of additional affidavit. That was earlier allowed, the plaintiff is allowed to adduce the evidence of official witness regarding selling.
Yes. Where is your list of witness?
List of witness, when it was submitted, but
Where is it?
in the list of witness, there is no official witnesses names are also there.
No, no, that is the most important.
Now, your lordship desire to file affidavit
Hmm.
on certain points only. Kindly see your lordship's order, page 32. In the meantime, the petitioner, by way of filing an additional affidavit, shall bring on record the application so filed, which led to the passing of the order dated 10/1/25, written objection, if any, filed by the defendants in the said suit, as well as also provide an explanation as to why the order dated so and so have been assailed by filing application on 26/25 after more than 4 months.
Hmm.
So that to our application we have annexed now,
No,
and
no.
their objection we have annexed now. And regarding explanation of delay, my lord, because we are on good faith that as the matter has been earlier allowed, so definitely this time shall be also allowed.
Where is this? In some order passed by this court?
That is page 31.
Now in CRPIO 201? Oh, this is the case.
Yes.
Whereby rejected the petition wide annexure 6 of Iman. Thereafter, the suit was fixed on so and so for cross-examination of the witness on Iman, and on Iman, the learned court fixed the matter on Iman for commissioner. However, on Iman, no report of the commissioner was received, and hence the copy of the order dated so and so was sent to the commissioner. Thereafter, the case was fixed on Iman and Iman for cross-examination, and on the same day, the matter was fixed for so and so for commissioner. That on the earlier occasion on so and so, they were allowed to adduce official witness in respect to date, but due to different reasons, the same could not be materialized for the verbal submission of the. Where is this order annexure G? Heard both sides on Naaman on the petition filed by the plaintiff, under the defendant side stated that they don't have any peruse the plaintiff. It appears that they have taken the plea about having been lost. In light of the above, the plaintiff are allowed to need secondary evidence on so and so. Okay. Then why didn't you take steps earlier? The council, because of the mistake of the council.
Actually, that should have been given, but in between, sometimes the presiding officer was also absent, and the commissioner's report was.
Mr.
also-
Mahmood, are you complaining about the court or complaining about the council?
No, he was on maternity leave.
Who?
And presiding officer for some time.
How does it make a difference?
Only for necessary order, no evidence.
No, understood, but why didn't you take steps for official the issuance of summons?
That should have been taken because it was allowed by the learned.
So the
court.
mistake is of the lawyer.
Yes, 50 years, it was allowed.
Mistake is of the lawyer.
Lordship is for the mistake of lawyer, party should not suffer.
I know that. So what I do is impose a cost upon that lawyer. Now in this case, I'll impose a cost upon you. You take it up from the lawyer. This is how it
We
is.
are simply annexing the documents.
No,
We can provide-
I will impose the cost upon you, so you get the money from them, from the lawyer who engaged you here.
No, my lord, that order is maybe some a little
No,
injurious for
no,
my
that is
future.
what I do nowadays.
No,
The mistake of the lawyer cannot be a ground unless you take action against that lawyer. Why is that lawyer still representing? Is it the same lawyer who is representing? Then that means it is your mistake.
we have simply produced the,
Cost of 25,000.
so we have simply produced the papers.
Whatever may be, you have allowed the suit thereupon to proceed. Now, what is going to happen to those defendants? Because of this, I have to state, these proceedings would not have
Yes, my lord, they
arisen.
have so many times.
Forget about them. I'm not on that. But I'm asking you because of you, this has happened. Chalo. If you notice, making it returnable on 16th of July 2025.
My lord, may I propose one thing?
Steps be taken upon the respondent numbers 1, 2, and 3 by registered as well as usual. In addition to that, the petitioner is directed to effect service upon the respondent numbers 1, 2, and 3 by way of dusty routed through the registry of this court and file an affidavit of service on or before the next day. First, the case of the petitioner herein, the petitioner had challenged the order dated 10/1/2025, whereby the application for calling the official witness was rejected on the ground that at the time when the petitioner, who was the plaintiff, was adducing his evidence, he did not take appropriate steps for the purpose of for the purpose of summoning the official witness. Full stop. The learned trial court also observed in the impugned order that though on the earlier occasion by an order dated 25/3/2019, the learned trial court permitted the petitioner to lead official witness, lead No, this order has no relevance.
No, it is rejected, can you see?
No. 25/3/2019. 25/3/2019 does not allow you to produce anybody else. You are to give the secondary evidence on respect to the document, meaning thereby you can give the certified copy.
That is the evidence that our petition was to that effect, that official witness.
Where is that petition?
That petition, kindly see page 50 order, have both sides on petition number so filed by the plaintiff. Under section 65 of Evidence Act, the defendant side has stated that they do not have any objection to the state.
So you have been allowed to adduce secondary evidence.
Yes.
Where is your evidence that you want to call for that official witness?
Official witnesses list was submitted,
Where is that?
that is in the LCR.
Produce
And,
that.
and another thing, my lord, whether someone was issued or not, that is not, I have no information regarding that. But court allowed him to adduce secondary evidence.
So secondary evidence, you give it. Give the certified copy, that's all.
Certificate to be, my lord, that, certificate to be the official, original is lost. Certificate to be, I will allow, all the witnesses who adduce their witness in the cell deed, they have died, which is cell deed of, my lord, I think cell deed is of 1978. Or like that. So, in certain.
75. But you have to give that official witness. Where is yours? Did you take steps for issuance of summons?
Right.
Then, did you name them in the list of witness?
Kindly allow me 5 minutes time, I call. 5 minutes time, I call whether someone was.
It's okay, yeah. কি লিখিলে last line টো?
Very simple matter, man.
This is not a simple matter. It is, you want to circumvent order 16 rule 1. Ah, Mr. Mr. Mahmood, I understand what you are trying to do. You don't give in the name of list of witness.
No, I have
You
given.
don't, you don't mention, you don't take steps for issuance of summons. Later on, now you have realized at the time of cross-examination of the defendant witness, oh, I want to adduce the evidence of an official witness, isn't it? Then that I understand what you are trying to circumvent by saying all these things. So therefore, the cost has to be given of the, now it is 50. 50,
Rupees 50.
1,000.
It is so small.
এটা লেখক কি লিখিলে last time টো?
But let's take the instruction. I may withdraw the case.
হ্যাঁ? To adduce secondary evidence in respect to the deed number 9520/75. But the counsel, but the evidence of the plaintiff having been closed on the verbal submission of the learned counsel appearing on behalf of the plaintiff, comma, and the defendant have already submitted the examination in chief, comma, the said application so filed by the plaintiff could not be allowed. Full stop. Mr. M.U. Mahmood, the learned counsel submits that the
Withdraw the petition. 4% it may not possible for him to pay.
I am not imposing the cost today. Okay, Mr. M.U. Mahmood, the learned counsel appearing on behalf of the petitioner submits that the mistake is on account of the counsel who represented the plaintiff, who inadvertently did not think that for the purpose of proving the deed bearing deed number 9520/75 by way of secondary evidence, there was a requirement of producing an official witness in as much as the executors of the said deed as well as the witnesses have already expired. He therefore submitted that on account of the fault on the part of the petitioner, on the part of the counsel appearing on behalf of the petitioner should not be allowed to suffer. For taking into account the above, it is the opinion of this court that the petitioner have been able to make out a prima facie case for grant of a stay of the further proceedings of title suit number 03/2016 till the next date. Full stop. Accordingly, title suit number 03/16 pending before the court of the learned Munsif,
Civil
learned
judge,
court of the civil judge, senior division, junior division, Hosai, being title suit number here, shall remain stayed till the next date.
Share maybe can you call for, because that would clarify everything else here.
Mr. Mahmood, issuing this notice is too much. Giving you a stay is further too much. Asking the LCR is beyond comparison. It's beyond sky. There is no, it is not even in the space, it is in the moon. Someone asked that. But get ready with that 50,000. Tell me. Huh? Stay. What about the other side? Service not complete. Learned Council has deemed the service complete. Full stop. You want the transfer from where to where? Tell me, where's your file? You are appearing without a file. My goodness. None appears on behalf of the petitioner on call. Accordingly, the matter stands adjourned to be listed. Then, first of all, why do you carry the file and don't give it to your junior? You want the file means she will steal away. Huh? Run away with the file. Why don't you give it the file to your junior?
Service is completed. What you want.
Give the file to her. Give the file to her. What? You also don't have the file. The counsel appears before the court without the file and as such is unaware of the facts. Considering the matter stands adjourned to be listed after 4 weeks. Interim order passed earlier stands vacated. Next. No? Nothing. There's no interest of justice here. Interest of justice is just outside the door. I can't help it. If you have a helpless lady, you have to be more careful when you are there without a file. Next. No. Sorry. No, nothing doing. Give the seat to another person. Admission आहे नाही. None appears on behalf of the appellant on call. First of it is seen that the appellant have not been represented on the earlier 2 occasions. Considering the above, it appears that the appellant have lost interest in the instant proceedings for which the appeal stands dismissed for non-prosecution. Yes, what are you challenging, Mr.?
Number 2, is the owner of the land died in the meantime.
Huh?
Number 2
Died?
died.
When?
Arrest in January, my lord. Also, but there also come.
You are challenging the order at page 116. What is wrong with that order?
See, original.
Not on the old map, on the basis of the old map.
So maybe please see page 13, my lord.
Hmm.
In the middle portion, my lord.
Hmm.
As the land measuring 1 kotha was carved out of pata number 32, new pata number 443 was created. So revenue record was corrected by showing the name of the mother of the petitioner, that is JD number 3. Accordingly, a new field map was prepared in respect of the new DUG number 689 of new pata number 443. Accordingly, Abdul Nessa, JD number 3 and other family members are now in the possession of the DUG number so. The learned counsel on behalf of the DH orally submitted that the JD have admitted that 1 kotha of land covered by DUG number 688 of KP pata number 443 was carved out of old DUG number 270, and it is also admitted that there is a separate patta pertaining to DUG number 688. Before that, my lord, you will also may be pleased to see, I have already enclosed what the Nazir reported. Nazir reported, my lord, that the deed of delivery of possession 99. Respectfully, I beg to.
No, schedule A land is categorically mentioned in the plaint. KP Patta number 14 old, 32 new, dark number 77 old, 270 new. You did not challenge this. Did you challenge this boundary during the trial?
For declared tricycle interest in 2000, in 99, my lord. Then it was decreed, my lord, but there is no prayer for recovery of possession. Second suit was filed, my lord. Second suit was filed under section 6. And at that time, my lord, this petitioner who died recently, my lord, she was not a party in the earlier suit. But the decree was executed her.
Execution complete.
Execution now, my lord, is on the wrong schedule, my lord.
Have they completed?
Part of the, my house was demolished. And they put a schedule, my lord, which is not known.
Hmm.
earlier.
Hmm.
Your lordship, on the same day, they passed the petitioner, number 2, before your lordship passes 1 kotha of land, and the predecessor interest of the opposite party also passes 1 kotha of land. In my land, my lord, there is a map, schedule, that is a part of the whole land, but they have no schedule, my lord,
Hmm.
or nothing, map or nothing is there, my lord.
Hmm.
Now, holding, my lord, on my land. They also got a holding on their land. Where I do not know. But now, my lord, they filed a suit. Declaration of right title of interest on my part. Your lordship,
Hmm.
I have enclosed the copy of the original plaint, my lord.
Hmm.
They gave a schedule. Where from that schedule they got, my lord, that is not known.
Did you challenge the schedule in your written statement? I'm
Yes,
asking you, where is that? That this schedule is fictitious in your written statement? Where is it?
First plaint was, my lord, against the other and the petitioner number 1. That suit was decreed, my lord.
No, no, no. Where have you contested the schedule in your written statement? You have not. Kindly see page 78. Not done. No case. Dismiss. Chalo. Heard Mr. P.K. Kultar, the learned counsel, senior counsel, assisted by so-and-so, appearing on behalf of the petitioner. Mr. A.C. Sharma, the learned senior counsel, assisted by so-and-so, appearing on behalf of the respondent. The petitioner have challenged the order dated
My lord, page 80.
challenge the order dated. Where is that order?
In this respect, the defendant further states that
Order dated 24/1/2024. Passed in petition number 247/23,
page 80, my lord.
whereby the application filed under section 47, read with section 151 of the Code of Civil Procedure, challenging the executability of the decree passed in
In title suit number one thirty-six
36, 2018. In title suit number
second suit is 136 of 2010
136/2013.
under section 6 of the specific.
Whereby the petition filed under section 47 read with to section 151, challenging the executability of the decree dated 36/2018, passed in title suit number 136/2013, was rejected. It is seen that pursuant to that the learned trial court by the learned trial court, that is the court of the learned Munsif number 1, Kamrup Metro at Guwahati, had decreed the suit in favor of the suit being title suit number 136/2013. Thereby granting a decree in favor of the plaintiffs for recovery of possession of the Schedule A land by evicting the defendants and removing all structures constructed by the defendants or their men, agents, employees over the said land. It is relevant to take note of that in the title suit being title in the title suit being in the title suit in the suit being title suit number 136/2013, the plaintiffs have sought for recovery of possession of the Schedule A land. The Schedule A land, so described in the plaint of the suit, is as hereinunder. It page 76 of the Schedule A. Full stop. This court have duly taken note of that in the written statement filed by the defendants, the schedule to the plaint was never contested.
No, my lord, page 80, your lordship may be pleased to see page 80.
Where?
Page 80, my lord.
Ah.
In this respect, the defendant further states that there is no specific boundary in the sale deed of Mrs. Romana Ramon as claimed by the plaintiff.
That is not, you are not contesting the schedule.
My lord, because the,
This is specific in the sale deed. This is not the schedule. You have not contested the schedule in your written state.
and when the decree was passed against a party who was not a party to the earlier suit, my lord.
I'm not on that. I'm not going to see on that. There is a decree being passed in a suit. You should have claimed, you should have challenged the decree. It's a different thing. But for the executing court, they cannot look into this.
Here. 73, West. Afghanistan, sir,
However, pursuant to the decree so passed, an application was filed by the petitioners who were the judgment debtor, who was the judgment debtor, contesting the executability of the decree on the ground that the said decree contesting on the executive on the ground that the land so described in Schedule A, which was decreed, was not identifiable. Full stop. The learned trial court, after taking into account the application so filed and hearing both the parties, learned executing court, that is the court of the civil judge, Junior Division number 1, Kamrup Metro at Guwahati, taking into account the materials on record and the submissions so made by the parties, observe that during the pendency of the suit, on account of the settlement proceedings, resettlement proceedings, the DAG number and the Patta number have changed. And as such, directed the Nazir to execute the decree on the basis of the old map. Full stop. And submit the report.
Whole that one of the land, 4 bighas and. Here is the one.
Mr. Koilta, I think I also know how from the old map and new map, how the dark number can be traced. I think these Nazirs will know about this. You never challenged that the decree which has been passed. And this, the court have duly considered it. No, I'm not going to pass that. This order seems to be good. This court, having perused the impugned order,
Where from Munshi got this model?
finds it relevant to take note of the judgment of the Supreme Court in the case of this court have duly heard the learned counsels appearing on behalf of the parties and have perused the materials on report. From the materials on record, it is seen that the petitioners herein, who were the judgment debtors, never contested the schedule to the plaint in their written statement. Full stop. Admittedly, during the pendency of the suit, during the pendency of the suit, on account of the resettlement proceedings, there has been a change in the respective DAG numbers and Patta numbers. And it appears from the discussions so made by the learned executing court that these very aspects have been duly taken note of. This court further finds it relevant to observe that the executing court being conferred with the power to deal with the execution, discharge, or satisfaction of the decree. Has to find out and has to arrive at the conclusion as to whether the decree could be executed. And has to make out an endeavor, has to take appropriate steps so that the fruits of the decree is enjoyed by the decree holder. Full stop. In this regard, this court, judgment at a on what is the name of the judgment power? That judgment, you have the judgment that this is that paragraph 32. I remember the judgment. That these type of things shall not be allowed and should be stopped. And it is the word uses are bogies, B-O-G-E-Y, by the Supreme Court. This judgment I have referred to.
Schedule land. How they can own my land? That is the question.
Yes, I know. No, I don't want it. Okay. Yes, Sharma, you should have got that judgment.
Fixed value, that is correct, that if there is discrepancy, the boundary will prevail. But if the boundary prevails, fellow, then my land is not required. Part of my house. And my lord, at page
Kidnap Kumar to
101, my lord, I have already given. They summoned the circle officer and the last condo. But that was not examined and rejected the application and directed to execute the decree as per the old tag number. How much order can sustain, my lord? At page 101, my lord, I have given the order. Supreme Court judgment, my lord. 25, my lord. 47 application can also be treated as an application under order 21 rule 97. It is Periamol, my lord, versus Razamma.
If you want that, then I should dismiss it. Then I'll say that it should have become under 103. It will be a decree and go and file an appeal. You want that? Don't come up with that thing. That is another aspect. That judgment has on another. There's no business out here.
You're examining the circle officer and lot bundle by the
Mr. Kulta, I know I'll take care of your situation. I want a judgment which Mr. Sharma is not helping this court.
Yes, my lord,
I know that you see what is there, that the Nazir cannot go and do it on his own map. It has to be done in consultation with the revenue authorities. That is the order which I am going to pass. But the question of stay of the execution does not arise out here. I know that because the Nazir cannot look into that. It has to be done with the help of the revenue authorities. So the direction will be passed to that extent. I will interfere to that extent. That I know what I am doing. But I wanted that judgment which is there. I remember reported refer so it like that. সিদিনা refer কৰিছিলো তো, ধীৰ। মই দি দিম বাৰু পিছত। 2008 ত হৈছিল। This court duly takes note of the judgment of the Supreme Court in the case of so and so, wherein the Supreme Court categorically observed that where there is no challenge to the schedule in the schedule during the trial, comma, at the time of execution of the decree, that this the schedule to the challenge to the challenge to such the challenge made to such description of the schedule land should not be permitted. Full stop. Paragraph so and so of the said judgment being relevant is reproduced hereunder. Full stop. This court have also duly taken note of that the learned trial court, a learned executing court, having taken into account that there was no challenge to the schedule to the plaint during the trial, and the dag numbers and patta numbers having changed, have directed, had observed that this aspect of the matter would not impact the decision of the court. Full stop. The said opinion on the part of the learned executing court, the said observations and the said observations made by the learned executing court in the impugned order, in the opinion of this court, appears to be correct. However, it is this court also finds it very pertinent to take note of that the civil nazir, the pertinent to take note of that the learned trial court, executing court, instead of directing the civil nazir to take steps for execution of the decree with the help of the revenue authorities, directed the civil nazir to take steps on his own for execution on the basis of the old revenue map. First, this, in the opinion of this court, was not proper, taking into account that the civil nazir did not have the expertise in that regard.
The report shows Nimbodian age, Ami Mantarike,
Mr. Sharma, first of all,
police,
no, that civil nazir could not have looked into the old trace map. He had no expertise.
Mandal Kanangu,
So that is why that should have been the direction, that he should execute with the help of the revenue authorities.
the Nazir went to the
But then thereafter did he execute? No, we are only concerned with the challenge to this order, 24/1/2024.
My, my affidavit in opposition, page 151.
Accordingly, this court, though is not inclined to interfere with the manner in which the learned executing court had proceeded with the execution of the decree, comma. However, the direction so issued to the civil nazir to execute the decree on the basis of the old map requires interference. Mr. Sharma, it has been executed.
My report is, Nazir report is in my affidavit.
No, it has already been executed.
It is executed on 25/2/24.
This is the judgment. Ravinder Kaur versus Ashok Kumar and others reported in 2003, 8 SEC 8289. Paragraph 22. It has been submitted by Mr. A.C. Sharma, the learned senior counsel, that based upon the directions so passed in the impugned order dated 24/1/2024, the execution has already been carried out and the decree has already been is duly satisfied. Taking into account the above, as the decree have already been executed, this court would not now be in a position to interfere with the order dated 24/1/2024, although the directions issued to the civil nazir to execute on the own map without the assistance of the revenue authorities was not proper. Accordingly, this court closes the instant petition. But, however, gives the liberty to the petitioner, who is the judgment debtor in the said proceedings, to file appropriate applications before the learned executing court. Under section 47 of the code. No, you have no other way, because 102 bars you. Section 47 of the code. As per the appropriate provisions of law, including section 47. Taking into account that the learned executing court continues to retain jurisdiction over the decree, even after, in respect to the decree, even after the closure of the execution proceedings. Full stop. This court further observes the learned upon such application being filed, comma, the learned trial court, executing court shall adjudicate the same on its own merits without being influenced by the order dated 24/1/2024. Hmm?
The MSC case, the original MSC case. Okay,
Why?
that's it for want of jurisdiction.
Which court dismissed it?
It is MSC Guwahati.
Accident occurred where?
Accident occurred in Balajan, JD Road, Balajan.
Huh?
Not within the jurisdiction of the MSC Guwahati.
Accident happened where?
That's it. JD Road, Balajan, Pokrajhar.
Where's your claim petition?
Claim petition is at page 8.
Hmm?
Page 8.
In
JD Road,
Kokrajhar?
Yes, sir.
Okay. Then
But see, he was temporarily
you stay where?
or a permanent resident of ZD Road, Balajan, but temporarily residing at the place of within the jurisdiction of MSC Guwahati at the time of accident. On
Show
the
me.
day of- There is a affidavit executed by the
No affidavit. Show me something, some document you show me.
only the landlord has executed one.
No.
But there is no such document. The landlord saying that it was executed on 27/3/2023.
Accident happened when?
Accident happened.
23.
Yes, that's
Okay. Has the DAR been given, submitted? It's an accident. Yeah, there must have been FIR.
FIR also. There is a GD entry.
No, there cannot be a GD entry
There is-
business. What
there
is
is a-
this GD
No, no.
entry?
Pokrajhar PS case number 101 of 20.
So what happened out there? Have they submitted the DAR?
Take instruction. 23 meter also 2793048.
Was the only reason why it has not been admitted.
Not admitted.
Why so long?
But actually, I was asked to bring some document showing that I was residing at the place within the jurisdiction of MSC Guwahati at the time of work. So I
Tola Mangalam. Who is the counsel?
Kola Mandal also I have searched online also here. I think only one office in Guwahati and the Assami Guwahati.
देखो। This is an appeal filed under section 173 of the Motor Vehicles Act 1988, challenging the order dated 14/9/2023, passed in MSC case number 167/2023, whereby the application filed claim proceedings was returned for filing the same before the appropriate tribunal having jurisdiction. Why you're not filing it at Guwahati? What is the problem if the one of the defendant resides out there? It can be done out there.
I was not a conducting counsel here.
Huh?
I was not a conducting counsel.
Not necessary. Why you are not filing it at Guwahati matter? Because you see, if I admit the appeal, it will have an impact. This will get delayed. When it will be finished, you never know. But your client is going to suffer at the end of the day. That is the only worry. This court inquired with the learned counsel appearing on behalf of the appellant as to why the appeal is not filed at Guwahati, the claim proceedings upon being returned is not filed before the appropriate the learned tribunals at Guwahati. In as much as the learned motor accidents claims tribunal at Guwahati would have the jurisdiction taking into account that the opposite party number one has its office at Guwahati, one of the offices at Guwahati. The learned counsel submits that he will obtain instructions and place the matter before this court on the next date. Place the matter on, we finish it out before vacation on 25th. You just give, what I do is give you the liberty period during this, taking it out, you file it out here. Matter is over then. Huh? That seems to be more because keeping this appeal pending makes no sense. And it is going on from 2023, unnecessary.
The section 18, while deciding a reference in section 18. The basic ground, my lord, here is that the reference filed by the landowners, my lord, before the Dhaneer district judge itself was time barred. And it was not in consonance with, my lord, section 18 of the Land Acquisition Act 1990. So that is the primary contention, my lord. And secondly, my lord, the entire land acquisition amount which was directed to be paid was paid by the Union of India, my lord, the SSB authorities, my lord, on 25/8/2008 itself. So therefore, my lord, there was no due amount to be paid. And in fact, it was the Deputy Commissioner, my lord, who has delayed the payment of the compensation amount which was initially fixed in respect of the land which was acquired. My lord, here when the section 18 application was filed before the learned, my lord,
What is the challenge here?
the challenge is the order passed under section 18, my lord, by the district judge. That is at page 36.
certain lands were acquired, my lord, the landowners thereafter filed a reference in the section 18 claiming a higher amount of compensation. But that reference itself was time barred, my lord, because the compensation was paid to the landowners long back in the year 2008 itself. And the reference was filed, my lord, in the year 2014.
No, that additional amount which have been sought for, that amount has been not given,
Not given,
not given.
not given.
But only thing which have been given is the interest.
Yes, rest,
You are only agree with because of the interest.
not the interest, my lord.
Yes,
In fact, the entire amount was paid, if my lord.
understood.
Yes.
Your case is that you have paid it to the deputy
Yes,
commissioner.
yes,
The deputy commissioner did not pay
Yes,
it to them. That is your
That
case.
is,
Your case.
yes,
But the question is, as regards the interest,
Hello.
it should be the deputy commissioner who has to pay,
yes,
not you.
yes.
So under such circumstances, the direction is only given to the deputy commissioner.
Not the issue of limitation is also there.
What
The
limitation?
reference
The
was
question
time
of
barred.
limitation does not arise. That has been already rejected. Additional amount has been rejected.
No, my lord, the reference, my lord, if my lord takes section 18.
Hmm.
How can reference be filed? My lord, it says any person who has not accepted the award may by written application to the collector require that the matter be referred by the collector for determination of the court. Whether his objection be to the measurement of the land, the amount of compensation, the person to whom it is payable, or the apportionment of the compensation among the persons interested. The application shall state the grounds on which objection to the award is taken, provided that every such application shall be made if a person making it was present or represented before the collector at the time when he made his award within 6 weeks from the date of the collector's award. In other cases, within 6 weeks of the receipt of the notice from the collector under section 12, subsection 2, or within 6 months from the date of the collector's award, whichever period is early. Here, my lord, in the reference application file, there is no mention of the fact that when the landowners approach the deputy commissioner by making an application, there is also no mention of the award. They have not annexed the copy of the award also when the
When
award.
they approached the deputy commissioner is on 29/2/2012.
Yes, my lord, that is reflected in the petition, but the copy of the application is not there, my lord.
Hmm.
And this petition 29/2/2012, my lord, is not sure whether
This is your document you have enclosed. You cannot say
This is
deny
their
that.
petition, my lord. My document.
But you have enclosed this.
Yes.
Then you
But
have to
it does-
admit it. This is the petition for a year. They did not get the money, you did not pay the money till 22/12. The deputy commissioner did not pay them the money till 22/12/2011.
my lord.
Then
See, it is from the date of the award, my lord, the section 18. The reference has to be filed within 6 months from the date of the receipt of the award.
oh, is it?
My lord,
Read
section,
it properly.
my lord. Provided that every such application shall be made if the person making it was present or represented before the collector at the time when he made the award within 6 weeks from the date of the collector's award. And in the second condition, my lord, in other cases, within 6 weeks of the receipt of the notice from the collector under section 12, subsection 2, or within 6 months from the date of the collector's award, which our period shall first expire.
Now, did you challenge this reference?
This is under challenge, my lord.
No, did you challenge the reference? This is an executive order.
Any reference we have not
Well,
challenged.
no,
Any reference we have not challenged.
the Supreme Court has been clear that from the date of their knowledge,
No, my lord, it is not. I'm just. It is,
you are referring to
1996, my lord.
there is Justice Sema's judgment. Isn't it?
Yes, Yes.
Thereafter, there are 3 judges bench judgment. There's subsequently, there is other judgment wherein says from the date of the knowledge.
My lord, another reference.
Anyway, the direction is given to the deputy commissioner. The deputy commissioner will pay. The direction is not given to you.
My lord.
Then, kindly see that order. Kindly see. Page paragraph 23.
My lord, page 59, the decree, my lord, says that the deputy commissioner shall do the needful for calculating the compensation as awarded by this court and do the needful for seeking funds from the opposite party number 2. That is the,
So there has been an enhancement to 6 lakhs.
Yes.
Could have been taken as 6 lakhs.
Yes, my lord, it so happened the government valuation of the land is 6 lakhs. In 2005, part of the land, same patta, half of the land has been taken for national highway enhancement, and then 6 lakhs was given. Government valuation is found to be 6 lakhs. It is in paragraph 14 of the judgment.
So thereafter, therefore,
Yes. So it has
there
been
will
enhanced.
be interest in terms with section 28
Yes, my lord.
for the amount above 2,61,790.
Yes, my lord. It was given at 4,19,000 per bitha. Should have been 6 lakhs per bitha.
Okay. And how much was the land?
Land is 2 katha 10 lesa. Half of the 1 bitha land. Half has been taken by National Highway 37 enhance.
So it should have been 6 lakhs.
Yes, my lord.
2 katha? How much? 2
2
katha?
katha 10 lesa, my lord.
So that means it should have been 3 lakhs.
My lord, I just have a look at it.
2 kattas, 4 lesa.
4 lesa, my lord.
So the amount should have been 2,61,000.
Yes, my lord. 2,61,791.
And you were given how much?
2,61,791 is the given based on 4,19,000.
No. If it is 2 kathas, 4 lesa, how much it would be? Two katha, 4 lecha.
Yes, my lord.
2 katha, so if it is taken at 6 lakhs for a year, it's 60,000 per lesa, isn't it?
Yes, my lord.
6,000 per lesa. 6,000 per lesa is equals to how much? This is 44. If it is given at 6 lakhs, it will come to 2,64,000 or not. Isn't it? And you were given at what?
261,
A sum of
791.
rupees was paid to the petitioner through Iman. Aforesaid amount was subscribed by a year. The reason the compensation was received was not adequate and so and so. Belonging there which was also acquired was fixed at rupees so and so. That instead of market value was fixed at rupees Iman instead of Iman and as such so and so. That the plot of land of Iman was taken on the 4 lane at rupees was paid compensation of rupees 3,36,000, taking the market value of the land at rupees 6 lakhs.
My lord, it is written in para 4. It is also stated that a plot of land measuring 2 kathas.
Now that I understand. This is another land.
No, same land, my lord. So,
This is another land. This is under the national highway.
yes, that same. So out of 1 bigha. So the remaining is there, 2 katha 4 lesa.
So how much should that be if it is taken as 6 lakhs? Because here we are only concerned with 2 lecture, 4 lecture. So if it is taken at 6 lakhs, per biga, means 6,000 per lesser,
Yes.
which comes to how much? 2,64,000. 2,64,000 would be the market value.
Yes.
Then there will be 30% solation.
We are paid, my lord. In page 27, para 4, it is written.
You have been
Page
paid how much?
That for a 2 kata 4 lesser of land, we have been paid only an amount of 2,61,791.
2 lakhs,
61,791.
61,790.
One.
Okay. 790 it has been mentioned. Anyway, so it should have been 2,64,000.
Yes.
This is the, as per valuation under 23, 24-1.
Yes.
Then you have another 30%.
30% solation. It's
30% solation.
Yes.
So
21.
30% solation on this amount will be how much?
$79,200.
79,000.
If we take entire 2,64,000.
You have to take on 2,64,000.
Yes.
30% solation will be how much?
79,200.
79,200 plus interest
9%.
from the date of the notification under section 4
Yes.
till the date of the award at 12%. How much? You have not calculated.
That I have not calculated. My lord, I have not received this memo also today.
You know that award
Yeah, I got it. I got the award. My lord, I have not.
because I'm going to dismiss his appeal now.
Yes, my lord, that Kolkata Municipal Corporation versus that,
Wherever Kolkata does not come into the scene here.
yes,
How much?
figure, my lord, I have not calculated.
Then how do you help this court? If I admit this appeal, it is Mr. Because then I can direct them to pay that 50%.
In fact, the copy of the award has also not been, the reference was filed. Because our stand is that, my lord, we have paid the entire amount. There is no amount due.
Whatever may be, you may have paid
And
the amount.
after the award, my lord,
Whatever may be, you can very well take it up with them. I'm not concerned with that. They have asked you to write a letter to them, whatever may be. But as regards the additional amount you have to pay,
for that, my lord, the assessment ought to have come, my lord.
so after the judgment which have been pronounced, the amount should have been arrived at. So the counsel appearing on behalf, you are on caveat.
No,
Then why you are appearing?
our name is showing because we appeared in IA for condemnation of bill.
You have not filed wakalatnama, we
Yes,
shall
sir.
not hear you. So we stay the entire thing as they are not helping this court. But at the end of the day, Mr. Gupta, what is going to happen is you'll have to pay a huge interest because the interest is running at 15%. On merits at 6 lakhs, there's nothing to touch.
Ma'am.
Okay. So therefore, that amount will be there, 2,64,000.
Because of
Because you see, as per section 28 of the old act, first is 9% and then 15% from that date. Because that actual compensation has to be paid ends on that date. So from 2009 onwards, this will run. Which makes it the big problem which is there. Now it will be running at 15%. And this 2,64,000 or otherwise 30,000 a year, because they will be happy now if I admit the appeal. Because if I admit the appeal, then the question is, if that money, even if they put it out there before in the bank also, they won't get so much. So at the end of the day, you will have to bear the burden. The question is only as regards 15% interest for this period is too small an amount. For that, fighting out here does not make any sense. Get the point? Fighting out here, this is on 2,61,000, whatever member. This is only for 2 years at the rate of 15%. First is 9% and the second is 15%. So 1 year 9%, the other is 15%. This is not the bigger issue. The bigger issue is the other one, because this amount is now would be touching something around 4 lakhs. So you have to pay on 1,44,000 from 2009 onwards till date, which is for another 16 years at 15%. Just imagine what would be the amount.
So that only, my lord, my submission was, my lord, when this entire amount was paid,
Mr. Gupta, you have paid 2,61,000. I'm not on that. That is not the bigger issue. You are to be entitled to get the interest only for that period. That is a too small an issue. That will be how much? At best, it will be 25,000-30,000. But the bigger issue is the other one, which they will be happy to keep the appeal pending out here. For me, it is okay, no problem.
Can I file the affidavit, wakalatnama, and can it be listed on Monday?
You have to come up with that
I
figure.
had also come up with the figure.
You first see Gurpreet Singh,
Yes, my lord.
that Constitution Bench judgment.
Yes,
When an amount is being paid,
yes, my lord.
how it is to be apportioned. Then I have delivered to 2 judgments on this point. How it is to be apportioned, the interest. Because nobody says there is an interest, because you have to see paragraph 50, I suppose, that judgment. What happens is, first it will be appropriated against the interest and the principal continues. So you have to make that calculation and come up before the court. Then in that regard, we dismiss his appeal and direct them to pay. Then you may get whatever you may. But the question is, otherwise the union will unnecessarily have to bear a burden if I keep this appeal pending for long. Makes no sense. So on Tuesday we'll finish it off. 24th. Mr. Gupta, you see that Gurpreet Singh's judgment and Sundar and Gurpreet Singh, how it is to be calculated, and thereupon we can very well arrive at what is the amount. And in that regard, there's one matter which I have duly dealt with the evidence. Counsels appearing on behalf of both the parties seeks for an accommodation. This appeal again on 24th of June 2020.
Passed in the IA, madam. IA number 249.
What is that? You have entered into some settlement.
Yes, my lord. They personally appeared before this honorable court on 3 occasions, my lord. And there was chances of a settlement, so
You want an adjournment?
adjournment, yes.
Ms. So-and-so appearing on behalf of the appellants seeks for an accommodation, list the matter of the vacations. You filed the affidavit.
Page 248.
Claim number 9, who appeared? You appeared. You are in this case. So this undertaking is there.
Yes.
Heard Mr. S.K. Goswami, the learned counsel appearing on behalf of the appellant. Mr. S. Doctor, the learned senior counsel assisted by so-and-so appears on behalf of the respondent. The instant appeal has been preferred under Order 43, Rule 1R, read with Section 104 of the Code of Civil Procedure 1908, for short, the code, challenging the order dated 17/3/2025, passed in Mize case number 64/2023, arising out of title suit number 58/2023, whereby the learned trial court directed both the parties to maintain status quo in respect to the suit land till the disposal of title suit number 58/2023. Full stop. The learned counsel appearing on behalf of the appellant submitted that the learned trial court did not consider that the appellants were constructing pursuant to purchase of the suit land in the year
2003.
2003, where pursuant to constructing a building RCC. How many story?
2-story.
Constructing an RCC 2-storied building, and in that regard have you taken loan?
It's in sale permission, not loan, it's sale permission.
Huh?
Sale permission has been obtained from municipal corporation, like a building permission.
And in that regard have also obtained permission from the appropriate authorities. The learned counsel further submitted that huge investments were also made on the investments have been made in the part construction. Have you started on the part construction of the building? And the deed of sale of the year 2003 have been challenged in the year 2024. And the learned trial court, without considering the balance of convenience and the irreparable loss, harm, and injury, have granted the injunction thereby directing both the parties to maintain status quo in respect to the suit land. The learned counsel appearing on behalf of the appellant further submitted that this injunction, though may have been worded as to maintain status quo, the maintenance of status quo by both the parties, but it is solely affecting the appellants as they have been in possession over the suit land pursuant to the purchase made in the year 2003. The learned counsel further submitted that the appellant have also agreed to give an undertaking and for that purpose had filed an affidavit giving that undertaking on 17/6/2025. He therefore submitted that in view of the undertaking, comma, the plaintiffs oblique the respondents herein cannot have an objection to the further construction of the building over the suit land. Full stop. Mr. S. Dotto, the learned senior counsel appearing on behalf of the respondents, oblique the plaintiffs, submitted that although the plaintiff have a very good case in on merits, comma, but taking into account that the appellants herein are in possession of the suit land and they have raised certain construction, comma, on in view of the undertaking so given on by the affidavit dated 17/6/2025, comma, the respondents oblique the plaintiffs would have no objection in modification of the interim order of the injunction order subject to the binding, subject to the undertaking given before this court would remain binding upon the appellants during the pendency of the binding of throughout the proceedings, throughout the proceedings in title suit number 58/2023. First, this court have duly taken note of their respective submissions and have also perused the materials on record. From the materials on record, it is seen that the plaintiffs who are the respondents herein have instituted the title suit number 58/2023 challenging the you have not challenged the sale deed.
We have challenged. So now you can
Challenging.
See the plane,
Challenging the
that page,
huh?
the prayer question of the paint, you lost it.
Page 74.
74 onwards,
Number?
page 74.
Where is the sale deed challenge? No, you have not challenged the sale deed.
So the declaration that forming of partnership deed of partnership dated so and so. The partnership deed was challenged. And then, my lord, 4, declaration that the defendant number 9 and 11, Sita Devi Kanoi and Rajesh Kanoi are never the owner of the premises as respect and should lay.
Now, challenging the right of the defendants over the suit land as described in Schedule B to the plaint. Schedule over the Schedule A and Schedule A over the Schedule A land. Full stop.
In regard to 8 letters of land. In regard to 8 letters of land.
Schedule A.
It'll be your, Schedule A, then Schedule B also your lot will find 8 letters, more or less.
That's the same thing.
Yes. That's the same thing.
Schedule A. And the very partnership deed on the basis of which the plaintiff, the defendants have purchased the suit land. Full stop. From the materials on record, it transpires that there is a prima facie case for going for trial. Full stop. However, taking into account that the defendants presently are in occupation of the suit land, defendants oblique appellants are in occupation of, are in possession of the suit land since the date of the purchase, and had also given an undertaking as reflected in, as mentioned in the affidavit filed on 7/6/2025. It is the opinion of this court that the balance of convenience is not in favor of the plaintiff for allowing the injunction order to continue against the defendants oblique the appellants. First, this court have also taken note of that the appellants oblique the defendants having the right over the suit land on the basis of a deed of sale having prima facie right on the basis of the deed of sale and presently being in occupation of the said land, comma D, presently in occupation of the said suit land, and further having invested amounts towards the construction of the building, comma, the aspect pertaining to irreparable loss, harm, and injury would be more if the injunction order so passed by the learned trial court is allowed to be continued. More so in view of the undertaking given before this court. It is relevant to observe that this court have interfered with, is inclined to interfere with the impugned order of injunction dated 17/3/2025 in view of the undertaking given before this court. First, it is a settled principle of law that the undertaking given before this court would be deemed to be an undertaking would have the force of an order being passed by this court. First, in that view of the matter, this court, incorporates the undertaking so given in the affidavit dated 17/6/2024, which is mentioned at paragraph number 6 of the said affidavit. The same is reproduced here in under. First. Accordingly, this court interferes with the order dated 13/3 so and so, 17/3/2025, passed in Ms. J case number 64/2023, in title suit number 58/2023. Full stop. The undertaking quoted herein above shall be binding upon the plaintiffs, upon the appellants herein, who are the defendants in the suit. Defendant numbers?
Defendant number
1 and 2.
defendant number 945, no?
9,
9, 11, and 12.
9, 11, and 12. During the pendency of the suit, during the pendency of the suit. Full stop.
Problem. Plus 3.
Eh?
Building is G plus 3.
Reading
Building is G plus 3. Permission
G
is
plus
G
3.
G plus
3.
G plus 3 koriba or suit filing year 2023 day 24
23.
23 and you purchased in the year 2003
2003.
2000.
well the sale deed number
Sale deed number. Page 34. Also.
give the sale deed number you want an Indian
Item number 8, item number 8, she has appeared in item number 8 wrongly, Your Lordship.
item number 8 ako matokson item number 8 to bhul ke mat chun কোন বিসিটা এই নহয় এইটো বেলেগ নতুন কেছ Item number 8, what is this matter, Ms. Pukon?
This is appeal, okay, it has come from RTC, Your Lordship.
RCT?
Yes, yes, Your Lord, sorry. Railway Claims Tribunal, first time it has come, appeal admitted, Your Lord.
Huh?
Appeal admitted, last occasion they have filed one in.
No, appeal has not been admitted. I consult.
One day delay was there. Your Lord.
No, delay condone.
Yes, Your Lord.
Appeal has not been admitted.
Yes, Your Lord. It has come first time, Your Lord.
None appears on behalf of the appellant on call. List the matter. Ms. K. Pukon appears on behalf of the respondent. First, list the matter after vacation.
Okay.
It met appeal to job. The learned counsel appearing on behalf of the appellant submits that there is some talks of compromise going on. List the matter after 4 weeks.
problem.
Quantum of maintenance matter.
Quantum
Lordship.
for marriage.
My lord, decree of divorce has been granted. My lord, alimony so granted, my lord. And the husband,
You are challenging what?
my lord, only the maintenance part, my lord.
Not the decree of the, yeah.
Only the maintenance quantum.
Maintenance what?
It has been directed to pay 10,000, my lord, in addition to maintenance which have been paid by the appellant in 125.
You are the, how much? The petitioner filed by the year under 145/25, which has given rise to the instant case is allowed. The second party will pay maintenance allowance of 5,000 to the first party. That is rupees 2,000 AR to the first party and to the minor child. This is it. Page
My
32.
lord, page 10.
Ah.
Page 10. And relevant portion, lordship will see page 16. This is I have said.
What are you challenging?
Or page 16.
Hmm.
The plaintiff is directed to pay 10,000 per month to the defendant and her daughter as monthly maintenance until further order. The amount of alimony ordered in this case shall be in addition to the order under section 125 CRPC, which is already in force. So, my lord, already I have been paying, my lord, 5,000 per month to the, my lord, respondent.
So now 15,000.
My lord,
What is your earning?
My lord, he is a teacher, but my lord, his inability, my lord, I have explained.
Teacher where? Huh? What is you are a government servant?
His salary is, my lord, only
Why?
30,000, and he is maintaining his old age father, mother, and two nieces, my lord. I can
Huh?
certificate of
Where is your affidavit of assets?
assets and liability, my lord, I have filed.
Then?
File.
Then without filing it, how is it possible?
But request from both sides. My liability, my lord, is also in page 34. That may also consider.
Huh?
Page 34 for a moment.
You have maintained everybody except your wife.
I am also paying her, but my lord,
You are
the
paying 5,000.
5,000 in 125 CRPC, and in this
You
case,
with 30,000, first of all, you don't bring on record anything. With 30,000, you are maintaining your father, mother, elder sister,
and
niece, nephew, and what more?
that's why, my lord, it's difficult for me to pay 15,000, my lord. That's why, my lord, I have challenged one
And your father doesn't get pension. What does he do?
job.
No, obviously he's jobless. He cannot have a job at 74. Then you expect him to do.
That's why, my lord, the quantum is has been, my lord, directed to pay. This,
I don't find any goodness.
my lord, in the Rajneesh versus have judgment, my lord, that the Supreme Court, my lord, directed to, my lord, adjust the amount which have been already granted in previous proceeding that has not been done in this case, my lord. That is also one of the ground, my lord, that can be adjusted, my lord, 135 and the subsequent, my lord, this proceeding.
So you are ready to pay 10,000 now. 5,000 here and 5,000 earlier. In total. This is an appeal filed under Section 28 of the Hindu Marriage Act 1955, assailing the judgment and decree dated 31/8/2019 passed by the learned Additional District Judge FTC Kokrajhar in title suit D number 48/2015. Full stop. The learned counsel appearing on behalf of the appellant at the outset submits that the challenge made in the instant appeal do not relate to the dissolution of the marriage between the appellant and the respondent. Full stop. The only challenge to the said impugned judgment and decree is on the aspect that the learned trial court had directed the appellant to pay an amount of rupees 10,000 per month to the defendant and her daughter, to the respondent and her daughter as monthly maintenance, in addition to what has already been in addition to the order passed under Section 125 of the CRPC, which is already in force. The learned counsel drawing the attention of this court to the order dated page
27.
order dated 29/11/2014, passed in petition number 22/14, submitted that an amount of rupees 15,000 have already been paid, is being regularly paid by the appellant to the respondent. Full stop. He submitted that in addition to this 5,000, another 10,000 so directed to be paid, is on a higher side, taking into account the appellant has to take care, and the appellant receives a salary of rupees 30,000 and has to not only take care of himself, his father, mother, elder sister, and nephew and niece. He therefore submitted that only on this ground, the appeal be admitted. So taking into account the above, the appeal stands admitted only on the aspect as to whether the learned trial court was justified in directing payment of an amount of rupees 10,000 per month by the appellant to the respondent and her daughter, in addition to the amount of rupees 5,000 which the appellant have paid. Full stop. List the matter. Full stop. Call for the record steps be taken by way of registered execution.
Publish.
Stay আছে নাকি? Your file stay.
Separate. Carry this.
For
For execution. For stay of the execution of the with
How?
regard to the maintenance, madam.
Absolutely no, not in this type of petition. You have to file a petition.
Page 7, page 7
For what?
there, there,
Should I reject?
I'll file, sir. Alright.
Enhancement?
My lord.
Why?
Lord, my disability certificate not considered as a 40% permanent disability certificate.
The learned counsel appearing on behalf of the, the learned counsel appearing on behalf of the appellant submitted that the sole ground of objection taken is that the permanent disability certificate was not taken into consideration properly in arriving at the just and reasonable compensation, and as such, the present appeal is not taking into account the said ground of objection, the appeal admitted call for steps. Steps be taken. Delay condone?
Lordship already condoned.
Don't give it.
Public.
Yes, what is this?
Lordship,
Ground?
ground is two grounds, Lordship. First of all, the driver, the claimants had named some other driver in their FIR. But what happened, they made some other person as driver, that is respondent number 3 in this case, in the claim petition, Lordship. And that part, Lordship, already been admitted, Lordship. And again, Lordship, regarding some medical documents.
Wait. First, ground I have not understood.
Lordship may come to annexure 2, page number 18. Page number 2, annexure 2, page number 18, Lordship. Here is a cross-examination part of the claimant number 1. That is para number 1, 2, 3, 4, 5, 6, Lordship. It is been admitted.
What?
That is topically, son of Raja Bali has not been made a party in the present case as per Exhibit B, being certified copies of relevant documents of GR case number 2086 of 2020 is continuing against driver Sophically, who is shown as accused in the said case. So in the FIR, Lordship, also they have named this Sophically as driver of the offending vehicle. But in the claim petition, Lordship, they have named this respondent number 2, respondent number 4, Lordship, that is Atikur Rahman as the driver of the offending vehicle. This was the contradiction, Lordship. And this, again, Lordship, she has admitted that some exhibits she had produced, Lordship.
Mr. Counsel, first ground rejected. Second ground.
Second ground, that Lordship, some medical documents, she has admitted that those were not issued in her name. Those were not issued in, might be some misplaced because Lordship, misplaced because there is another claimant in this
Injury case.
injury case, Lordship.
What happened?
Both of the daughter and father were traveling in the offending vehicle, Lordship. And Honorable Tribunal has awarded 4,25,506 to claimant number 1 and 40,940 to the claimant number 2. That is the father. Number 1 is the mother. Daughter, Lordship.
So? What is wrong?
Lordship, LCR will reveal
What?
actually who was the driver.
I'm not concerned with the driver.
But Lordship,
You must have made some investigation.
yes, Lordship.
You know who is the driver. You, as per you, Sadiq Khan or whatever is the driver. Isn't it?
Lordship, GR
No,
case-
Mr. Counsel, kindly come. He is the driver.
Yes,
Did he have a license? I'm asking you.
yes, that is.
That
not
is-
issued. That is not it.
Matthias, that is not an issue. Now, what is wrong with this?
And regarding this medical documents, those were not considered in the award. See, those were not deducted. Lordship.
How much?
cannot right now because I don't have that medical document.
Then why you are making that submission?
LCR will reveal that.
Why should I? You don't get an appearance chance like this.
Also, LCR will definitely will, because I don't have that medical document. But I can produce on next that procedure.
Look into it.
Because these are, I think there are some substantial amount.
Only on 53,000 and 9,400. That is the only amount.
Yes.
Then pay the remaining. We'll admit the appeal along with interest.
Look, if I
53,000 and 9,940 is the ground of objection. Okay, pay the remaining along with interest. The learned counsel appearing on behalf of the appellant submitted that the sole ground of objection so taken in the instant appeal submitted that though various grounds of objection has been taken, but the ground or objection on which he would like to insist is that the medical expenses so awarded by the learned tribunal was perverse in view of in view of the fact that the evidence in view of the fact that the document, the evidence so adduced by the plaintiff did not substantiate awarding of amount of rupees 53,506 and rupees 9,940. Full stop. Taking into account the said ground of objection, the instant appeal is admitted. Call for a record, steps be taken, so and so. Next, stay is there?
Oh, no separate step.
No stay.
Separate, I haven't.
Okay.
In the memo appeal.
It will admit no harm. I think we should dismiss the appeal. No stay filed.
No separate step, but in the memo.
Full stop. Taking into account. But I can like to the ground of objection. Taking into account the said ground of objection, it is therefore apparent that the appellant duly admits the amount so awarded by the learned tribunal, except rupees 53,506 and rupees 9,940. Full stop. As the said amount, as the amount so awarded of rupees minus so under such circumstances, the claimants would be at liberty to institute proceedings for recovery before the tribunal in respect to the remaining amounts which is not denied. First, appeal is admitted, call for the records. Good case, bad case, which case?
Not a good case.
After vacation. This is the matter of the vacations. The matter after vacation. Transfer of what?
I don't have any communication. In the morning, I pray for adjournment.
Who prayed for adjournment? Why?
But no communication with the client.
Don't worry. Who is asking for the transfer?
Petitioner Lordship.
From
From Guwahati to Lordship, Nagaon,
what it do?
Nagaon Lordship. So I somehow procured the brief Lordship. I don't even have the brief Lordship. I somehow procured the brief from the petitioner, but somehow.
Where is the petitioner?
Lordship, I'm not aware of.
What does the petitioner do?
He was a lecturer previously, Lordship.
Hmm?
She was lecturer previously, Lordship, but currently, as per their petition, she is not working, Lordship.
Have you informed him? You have taken some consent.
No, I have informed that their matter is there. Lordship.
Okay, very well. Hello, we'll take it up at 2. Again. What is it? Yes, Mr. Das.
Not take up item 37.
Why?
Your lordship is familiar to the petitioner and respondent.
37?
Yes, ma'am.
Why?
This matter relates to BN demo.
So,
I thought my lord will not be with you.
I know those people only. They are dead. The father,
Yes,
Gautam Banerjee.
yes, ma'am. But Partha Banerjee used to visit your lordship. I'm told, ma'am.
Chalo. But you'll have a problem. What do you do about the interim? I can't extend it. If I don't take it, I can't extend it.
Can it be placed before another bench?
That also I cannot. I said not before me only.
All right,
Then
my
when
lord,
it
my
will
lord,
come, you never know.
That will,
Item number 37, not before me. Yes, do you want the transfer from where to where?
From family court.
Why? What do you do? Huh?
It was also pending in the judicial magistrate Nagaon.
Huh?
This case is also pending in the judicial.
Is it? You filed the WS? Have you filed the WS or not? Why? Hmm?
Instead of being
You want to stay with the petitioner? Respondent? Then why you are not allowing it to go ahead? No, I'm asking you. You don't want to stay with him. Then allow the lawyer to go ex parte. Huh? Why? Well, we vacate the interim order, the petitioner will come running back to you.
No, no.
I'm president of Guwahati Lordship and there are FIR lodged against me also.
You can, your one thing good is you don't have to appear every day out here. There you can engage a lawyer. Engage a lawyer there.
I don't have a
Transfer to-
communication lordship, one son's lordship.
Huh?
I don't have any communication with the client lordship, one son may be given lordship.
You don't need to have communication. He will know when it is transferred out there. Transferred. You file your written statement without fail on 11th. If you don't file, right goes. August. Transferred. What is the case about?
Citizen first the bill because dismissed for default, but on two consecutive occasions, the remain unrepresented. Thereafter, petition filed. That was also rejected.
Why it is rejected?
The grounds are not sufficient.
Hmm?
The grounds shown is not sufficient. Is there?
Hello? We allow you with a cost. Heard Mr. U. Datta, the learned counsel, appearing on behalf of the appellant. None has appeared on behalf of the sole respondent in spite of due notice. The petitioner herein, the appellant herein have assailed the order dated 26/11/2024, whereby the application filed under Order 41, Rule 19 of the Code was rejected, thereby rejected by the Court of the Learned Civil Judge, Senior Division, Hunitpur at Tejpur, bracket the Learned First Appellate Court. On the ground that the cause shown in the application filed under Order 41, Rule 19 of the Code was not a good cause, was not sufficient. This court have duly taken note of the materials on record, which shows that the appellant herein had prepared an appeal before the Learned First Appellate Court, which was registered and numbered as Title Appeal number 10/2022. On 5/9/2024, when the suit was fixed for, appeal was fixed for necessary order, on that date, the appellant did not appear. On the ground that the appellant had earlier did not appear on two consecutive dates, the appeal was dismissed for default.
Total 2 days. Total 2 days.
That is what the court says. Mr. U. Datta, the learned counsel appearing on behalf of the appellant, drew the attention of this court to the provisions of Order 41, Rule 16, and submitted Order 41, Rule 16, and Order 41, Rule 17, and submitted that the power to power under Order 41, Rule 17 of the court can only be exercised when the appeal was fixed for hearing. Full. He therefore submitted when the appeal was fixed only for necessary order, comma, the power under Order 41, Rule 17 of the court could not have been exercised. He further submitted that the learned First Appellate Court ought to have taken into account that on account of wrong noting made by the counsel appearing on behalf of the appellant before the First Appellate Court, the appellant did not appear, and as such the said cause were being a good cause, comma, the learned First Appellate Court ought to have exercised the powers under Order 41, Rule 19 for a readmission of the appeal. This court had duly perused the materials on record as well as the order by which the appeal was dismissed on 5/9/2024. From the very order, it is seen that the appeal was fixed for necessary orders and not for hearing. It is relevant to take note of that the power under Order 41, Rule 17 of the court could have been exercised only on the date when the appeal was fixed for hearing and not otherwise. Taking into account the above, the dismissal of the appeal by the order dated 5/9/2024 was contrary to the provisions of Order 41, Rule 17 of the Code. This court further finds it relevant to take note of that was the fault on the part of the counsel of the appellant which have led to the dismissal of the appeal. And this very aspect of the matter was duly mentioned in an affidavit in the application filed under Order 41, Rule 19. However, the learned First Appellate Court had taken an hyper-technical view and thereby rejected the application under Order 41, Rule 19 of the Code. Consequently, this court therefore interferes with the order dated 26/11/2024, whereby the application under Order 41, Rule 19 of the Code was rejected. This court further taking into account the reasons aforementioned exercises the power under Order 41, Rule 19 of the Code and thereby restores the title appeal being title appeal number 10/2022 to the file of the learned First Appellate Court. Taking into account that the appeal was dismissed, comma, and the appeal has been restored by the present order, this court fixes the appeal before the learned First Appellate Court on 21st of July 2025. The learned counsel the appellant herein shall produce a copy of this order before the learned First Appellate Court. Taking into account that the respondents are not represented, comma, the learned First Appellate Court prior to fixing a date for hearing, issue notice in the said appeal, intimating the respondents in title appeal number 10/2022 that the appeal have been restored and the appeal would be fixed for hearing. With the above, the instant appeal stands allowed. Where is your counterpart? No?
Number one, this petition against an impugned order dated 21/6/23, passed in title suit 178/22 by the learned Munshi Buri has rejected the WS submitted, and the prayer for direct the learned trial court to accept the WS submitted by the petitioner. Lordship, I have no any objection for accept the WS, Lordship.
Where is the counsel? I would have, I understand, but why is the petitioner not represented? Name has been shown. Who is this counsel? A. Rahman. Oh, wakalat naman kursus. How? A. Rahman E. Hussain. If I allow it also, he would not be knowing to file it. What to do? We'll see during the course of the day. Another time we'll take it up. If none appears, we dismiss for default. And vacate the stay order and dismiss it. In the meantime, inform. These counsels are absolutely courageous counsels, means they cannot be trusted. They can't appear when the matter is called up. This is all happens because of this. This counsel should be sent to the bar council. I think better off I allow his petition and send these counsels to the bar council. Yeah. Mr. R. Ali, please come forward. I allow you this petition and make him the amicus. And then send this counsel to the bar council. Gusto. None has appeared on behalf of the petitioner on call. When the matter is taken up, it is seen that the names of the counsels have also appeared in the cause list. Gusto. The respondent herein, however, the respondent herein is represented by so and so, who submits that on account of the pendency of the instant proceeding, the suit is getting delayed. It is very unfortunate that the petitioners herein have engaged the counsels, Mr. A. Rahman and Mr. E. Hussain, but they, for reasons best known, have not chosen to appear. First, under such circumstances, this court had requested Mr. R. Ali, the learned counsel, to assist this court for the purpose of disposal, for the purpose of the disposal, assisting in the disposal of the instant proceedings. And Mr. R. Ali have duly accepted, have agreed to. In the backdrop of the above, this court therefore takes up the instant proceedings. It is seen that the petitioners herein were the defendants. Numbers 1A, 1B, and 1C. In title suit number 178/2022. First, it appears that these defendants were subsequently substituted, were subsequently brought on record pursuant to the death of one Lolit Sarkar, who was the predecessor in interest of the petitioners herein. First, on the ground that summons upon the substituted legal representatives of the original defendant, number one, were served and the period of 90 days was over, the learned trial court had debarred the petitioners herein from filing the written statement. First, this court have duly perused the order, perused the application, and from the perusal of the application, it is seen, peruse the present application, it is seen that the written statement was submitted before the learned trial court on 7/1/2023. And there was a delay in accepting the delay in filing the same by 10 days. The learned trial court, however, are taking a very hyper-technical view and without taking into consideration the provision of section 148 of the code, declined to accept the written statement which was filed on 7/1/2023 by the impugned order dated 21/6/2023. This hyper-technical view so taken by the learned court of the Munsif number 3 Dhubri, now presently Civil Judge, Junior Division number 3 Dhubri, was an error, was an exercise in error of jurisdiction. Consequently, this court therefore interferes with the order dated 21/6/2023, passed in title suit number 178/2022, and further directs the learned trial court to proceed with the suit, being title suit number 178/2022, by taking on record the written statement filed by the defendant numbers 1A, 1B, and 1C on 7/1/2023. The interim order passed by this court accordingly stands vacated. Interim order dated 29/2023 passed by this court accordingly stands vacated. And the parties are directed to appear before the learned trial court on 21st of July 2025 for further proceedings of title suit number 178 of 2022. This court expresses its gratitude to Mr. R. Ali for assisting this court. What? What is your name? Why were you not there when the matter is called? So, I passed an order that you are sending you to the bar council. Go and file your whatever is required in the bar council. Because this is absolute negligence on the part of the council. Over to Gusai Diba, it Arali Gusai Diba, it Agorikini Gusai, he will lead you. What is your name? Next time, don't do it. Yes, what is this? One. Challenging the?
Order dated, final order dated 19.
Are you sure? CRP IO 215?
Yes, yes.
There's some stay to a judgment and decree dated 14/3. Huh?
Yes, yes, because challenging the order passed by the Learned Civil Court dated 14/3/23.
What is stayed?
This title suit has been stayed.
Which order are you challenging?
19/2/2024.
That is by which delay has been condoned. How much? Huh? Rejected. Then why you are filing this CRP business?
Because
You are challenging this under order 41 rules in a suit? Is it a decree? Is it a decree or a miscase?
miscase.
Huh?
We
First
filed
of all, you should know
we filed a
it's a title appeal.
title appeal along with
So, if that is dismissed, you have to file an appeal. Then, Mr. Sharma, anything?
No, your lord.
Any more enlightenment
No,
from
your
you?
lordship is right.
Huh?
Lordship
No,
is
no,
right.
give us. This very sad day. How are these type of petitions filed like this? What is that judgment 2001 3 SSC, na? Oh. This is the present heard Mr. S. Dr. Advocate, the learned counsel appearing on behalf of the petitioner, Mr. M. Sharma, who appears on behalf of the respondent number 1.
Yes, your lordship.
1. Respondent number 1. The supervisory jurisdiction of this court has been invoked, challenging an order dated 19/2/2024, passed by the Court of the Additional District Judge, Dibrugarh, in Mize case number 35/2023. Whereby the application filed under section 5 of the Limitation Act 1963, read with Order 41, Rule 33A of the Code, seeking condonation of delay of 75 days in filing the appeal against the judgment and decree dated 14/3/2023 passed by the Court of the Civil Judge Dibrugarh in title suit number 70/19 was rejected. Full stop. It is relevant to take note of that when an appeal, when an application seeking condonation of delay in filing an appeal against a judgment and decree is dismissed, is rejected, it amounts to confirmation of the judgment and decree by amounts to confirmation of the judgment and decree by the first appellate court. Judgment and decree of the learned trial court by the first appellate court. First, under such circumstances, an appeal, a second appeal has to be filed before this court and not by way of a revision, but not by, have to be filed before this court on substantial questions of law. First, taking into account that the Code of Civil Procedure 1908 specifically mandates a procedure, mandates an appellate remedy, the question of exercising the supervisory jurisdiction does not arise, for which the instant petition application cannot be entertained. First, accordingly, the instant application stands dismissed. First, next. Be it as it may, this court duly takes note of the submission of Mr. S. Dottor, the learned counsel appearing on behalf of the petitioners, who submit that on mistaken advice, the petitioners have filed the present proceedings and have been diligently pursuing. First, taking into account the above, and first, this court further takes note of that the instant application is being dismissed on the ground that it cannot be entertained in view of availability of remedy under section 100 of the code. Further, this court accepts the submissions so made by the learned counsel appearing on behalf of the petitioners to the effect that the petitioners have been diligently pursuing the present proceedings. Accordingly, the petitioners would be at liberty to prefer an appeal before this court. First, the period of limitation, appeal under section 100 of the code before this court, subject to substantial questions of law being involved. First, the period from 3/6/2024 till date be excluded while computing the period of limitation. Interim orders stands vacant. Secretary to dismiss. None has appeared on behalf of the petitioner on call. It is seen. That the petitioners have also not taken steps upon the respondent numbers 1, 2, 4, and 5, despite repeated directions being issued by the Lozima Court. And it is under such circumstances the present application is before this court. The non-appearance of the petitioner, the counsel for the petitioner today before this court, as well as the act on the part of the petitioner not to take any steps, clearly shows that the petitioner is not interested in pursuing the instant proceedings, for which the instant proceeding stands dismissed on non. Will respond number 4, Mr. Gusami?
Driver, he would not be required. Because the owner of the vehicle,
Is there. Mr. Al Gusami submits that taking into account that the owner of the vehicle is already there, the name of the respondent number 4 may be struck off, who is the driver. So taking into account the matter in the entirety, this court therefore strikes out the name of the respondent number 4 from the area of parties in the present appeal. It is further seen that the steps that the service is duly complete and the LCR has been received. Accordingly, list the appeal for hearing in the usual course, liberty given to both the parties to file appropriate application for early hearing. The counsel appearing on behalf of the appellant is directed to file a fresh memo of parties in view of the deletion striking out of the name of the respondent number 4 before the registry, and the registry shall begin. Steps not complete upon respondent number 1, 2, 3. You take fresh steps. Mr. Counsel appearing on behalf, Mr. So-and-so appearing on behalf of the appellant submits that taking into account the office note dated 13/6/2025, the appellant would like to take fresh steps upon the respondent numbers 1, 2, and 3 by way of registered as well as usual. Taking into account the above, the petitioner, the appellants are directed to take fresh steps upon the respondent number 1, 2, and 3 by registered as well as usual within 7 days from today. What about 2 and 3? Understood. What about 2 and 3? Service is not complete. Hey, I got order to review. Fresh steps upon respondent number 2 and 3 by registered. I got the 1, 2, and 3 as 2 and 3.
for respondent number 1.
Give your names. Item 20.
Yes, madam.
Not complete upon respondent number 3. Fresh steps. Service is not complete against some of the respondents. None appears on behalf of the appellant on call. Ms. So-and-so appears on behalf of the respondent number. Huh?
respondent number one, your lordship, two B, two C, and three, your lordship.
1, 2, so and so. To stop. The service as regards the respondent numbers 4, 5, 6, 7B, 9, 11, and 12 is not complete. It is also seen that the LCR of TA number 59 oblique 2013 have not been received. To stop. The appellant herein are directed to take fresh steps upon the respondent numbers 4, 5, 6, 7B, 9, 11, and 12 within 7 days by way of registered as well as usual. As regards the LCR, the registry further shall make reminders to the learned court below in respect to the LCR of TA number 59 oblique 2013. Yes, what is this?
But very taken dusty manner, file or affidavit.
Stays there?
Stay not there.
You want stay?
Early hearing, my lord, next week, my lord.
What is the matter about?
Matter is regarding, my lord, excessive exercise of jurisdiction by the executing court, by the trial court. Even after passing of the judgment, the trial court went on to make an inquiry with regard to the place.
Huh?
Regard to the location of the suit land.
After the judgment, not by the executing court. Oh, so very strange. Service complete.
Service more or less complete.
What is this more or less business?
Lordship,
I'm asking you,
Yes,
service is complete or
Yes,
not? What is this more or less business?
thing is that, my lord, the respondent number one took the notices on behalf of the other respondent. Now, whether lordship will accept that service or not, my lord.
No. Take fresh steps. What order you are challenging?
Order, my lord, is at page number 87, man.
Page? 80? Page? Ah,
87.
counsel for the petitioner is not ready with the matter. When the matter is taken up, matter stands adjourned sine die to be listed again when an application is filed by the counsel before the registry that the matter requires to be listed. Hey, to about to listed after vacation. Yes.
My lord, I have filed this certified form.
Oh. 23 today.
By the official affidavit
Oh, this one.
amendment of the
Oh, yes. Let us see the report.
additional
first.
every annexed B.
We have been daily dealing a number of cases, and as such it is difficult for me today to remember under what circumstances the case was made ready despite there being a defective order. After stipulating the file, speaking was found. Commercial suit.
Commercial.
You are the plaintiff.
Yes, right. Yeah.
Commercial suit, how things are to be done. It is not so easy. Now you can commercial goods. You can't apply the similar principles. Because what is now you are seeking to bring will have certain implications. It's not so easy. It's a commercial suit. Now, Mr. Counsel, how do we allow this amendment?
My lord, it is only the amendment. Do not change.
It is not
the
so
text of
easy.
the suit.
Without seeking an amendment to the affidavit which is to be filed under Order 6, Rule 15A. How do you take care of that situation? It is not so easy thing. It's a commercial dispute.
My, so far the order 6/17 is concerned. That has not been amended.
No,
by
no,
the-
no, no. You see, you have now to go as per Order 6, Rule 15A, which stipulates in the commercial code. Order 6, Rule 15A stipulates that you have to file an affidavit. Now you have to amend without that affidavit. That statement which you are making cannot be verified. You kindly see the commercial, the schedule, the appendix to the commercial code. Kindly see the schedule. In the schedule, there is an appendix. First of all, you see the schedule 4B.
4D.
4B. Okay. 4B Roman 2. after the rule 15, the following rules shall be inserted, namely rule 15A.
Appendix, yes, my lord, statement of truth,
No, rules, kindly see rule 15A.
15A.
It will be there in the commercial courts act.
Yes, my lord, 15A. Verification of pleadings in a commercial
Yes.
dispute.
Notwithstanding anything
anything
contained in
contained in
Rule
Rule
15, every pleading in a commercial dispute shall be verified by an affidavit in the manner and form prescribed in the appendix to the schedule. An affidavit under sub-rule 1 shall be signed by the party or by one of the parties to the proceedings or by any other person on behalf of such party or parties who is proved to the satisfaction of the court to be acquainted. Where a pleading is amended, the amendment must be verified in the form and manner referred to in sub-rule 1 unless the court orders otherwise.
So, my lord,
Where is your amendment seeking?
amendment, I.
Where in your petition, where do you say that you want that this has to be also given? This is like an election dispute. A commercial dispute is commercial courts had made it in such a manner. Kindly see what are the requirements as per the affidavit. Kindly see.
Yes.
This is in appendix 1. And again you see 4. Where a pleading is not verified in the manner provided under here, the party shall not be permitted to rely on such pleading as evidence or any other matter set forth. The court may strike out, which is not verified by the statement of truth, namely the affidavit set out. The court will strike out this.
But this was supported by the affidavit.
So therefore, you have to say in your application that you want to file an affidavit. How is this permissible? You have taken it like a simple case. One, that is one aspect. Second aspect, the problem arises is there recently the Supreme Court has come up with a judgment to that effect that in commercial court you have to come up with that, inform him previously. What is your case? And this is mandatory, held to be mandatory. If it is mandatory now, can you change the case subsequently? That is the pre-institutional thing. Now, can you change the case subsequently by way of an amendment? Unless subsequent events happen. This is not a case of subsequent events.
My lord, let this matter be taken up on Monday, and I would give this time proper.
You cannot file all this.
Because the petition is supported by the affidavit, the lawsuit will come to my petition, my lord. That has been supported by the affidavit as required.
What?
Statement of the truth, my lord.
Now, this would not help you. This would not help you. You have to seek an amendment and bring it there. There has to be an amendment to that affidavit also. In the plaint, this statement has to be there. Otherwise, how can you be allowed to insert something which is not there? Just for example, you want to insert the substitute paragraph 3. Now, this paragraph 3 has not been done. There's no statement of truth out there, which is required. How do you take care of it? Difficult?
Let it come on Monday.
Not satisfied?
Let it come on Monday, and I would say otherwise, my lord, I may be allowed to file this petition for amendment. In that case.
And what was the stage when we filed it?
It was prior to framing of the issue.
Issues have not been framed, but difficult with this type of application. Allowing you also have a problem. What is the ground?
Ground, my lord, I have taken because the order says that it will change the nature and character of the suit, my lord, even though that
Consistent
plea was
with
not
the
taken.
original plea.
And second,
Now you want the changing of the name.
changing of Because I want to aid one of the more party.
So how can you make a party without that pre-institutional thing? That is the big problem, na? Section 15, where is it? Section 15 or what? Pre-litigation mediation. That has been held to be mandatory recently. Oh, which one? Section 12. Pre-litigation mediation and settlement. A suit which does not contemplate any urgent relief under the act shall not be instituted unless the plaintiff exhausts the remedy of pre-litigation iman. Yeah, yes, 12A. This has been inserted by. You filed this application when?
My lord.
In a very recent judgment, it has been held that this is mandatory. You have to comply with this 12A. Because if you want to add a party, means it is a fresh type of litigation against him. Then how do you take care of that? Pre-litigational, yeah. Very difficult.
Because the other side did not appear. The
Appear or not appear, I'm not concerned. But you want to add somebody else as a party.
somebody else might. Save the dependent owner and the proprietor of Rajiv. Subsequently, they disclosed in their written statement that it is owned by HUL.
So therefore, now your suit is against an HUF. So if it is a suit against the HUF, that HUF has not been informed that you are filing a suit.
But the kata of that one was informed about.
No, kata is different. You cannot have the suit like this. Very
That
difficult.
amendment.
How? If you want to add somebody, if I allow you to file an fresh amendment to add somebody, because you want to add somebody now.
Yes, that
Meaning that by, if you want to add somebody or substitute somebody, whatever may be, it's against a new person. Then how do you take care of 12A, which is held to be mandatory now by the Supreme Court?
know that. Let it come on Tuesday.
After vacation, some better judge may help you out. I am not going to help you out. This is the matter of the vacations. No interim continuance. Better if you have limitation, withdraw the suit and file a legal year.
That is the problem.
You don't have limitation.
Now, there may not be any.
That is what you made a mistake. Problem arises in commercial suits is different. You cannot have it like this. This is a recent judgment of Justice Pardiwala on 12A. This is a very important thing. It has been held to be mandatory. Therefore, the problem arises, how does they do with order 1? They dealt with here. First schedule, order 1. Because otherwise one can do away with by, if you just want to implead, then what does happen to section 12A? Section 12A has been brought in by way of the Mediation Act. For the purpose of pre-litigation mediation, the central government may be notwithstanding anything contained in provided that the period of mediation may be extended for a period of 60 days, provided that the period during which the party spent for pre-litigation will not be computed or if the party. You have a look at that judgment, listen, pre-litigation, mediation, commercial, mandatory. You see, I told you, this is the judgment.
I will go.
This is because this I remember. If you have this, if it is mandatory, can you change the parties now? And thereby do anything. The very difficult type of suits which have become. Okay, after vacation. You want the date?
Let it be in first week of August.
So and so, Mr. O.P. Bhatti seeks for an accommodation to be was to list the matter on 4th of August.
In the meantime,
No, this court is not inclined to extend the interim order.
File for total, my lord.
Service complete? Service
And as
complete,
well,
as here received, list the matter for hearing in the usual court, liberty given to both parties to file application for early hearing.
Public.
Why haven't you taken steps by way usual
My
process?
lord, because some lapse, my lord, subsequently we have taken. We have taken subsequently, ma'am.
You have not taken, usual process not taken.
Not reflected there, ma'am. I think today they have given. Today they have submitted by usual court.
Hello, we vacate the interim order.
Otherwise, my lord, we have placed the order before the family court also. The husband is aware. But immediately thereafter, the matter was there.
Where the child resides?
Resides with the mother at Halyakandi.
Huh?
At Halyakandi town with the mother. All along she has been there. 7 years now. Our case is basically based on 9-1 only. We don't want to, my lord, it's not that the father's rights should be stifled, my lord, at least for guardianship or visitation. But then the jurisdiction as per the act itself is, my lord, in the place where the child ordinarily resides.
We have not produced the child before the learned trial court,
My lord,
in spite of orders being passed.
no. After that order, my lord, there was a stay. And that is also one of the reasons, my lord. Take the child, my lord, to Silchar on every date, my lord, it's difficult.
PW1 has already been discharged. Now you have challenged it for argument.
Yes, sir.
When it is at the stage of argument, now you want the transfer. Why should we transfer?
No, my lord, because there is no jurisdiction at all for state. It escaped the notice of everybody. In fact, the learned judge should not have registered the case there. Under the guardianship act, Guardians and Ward Act, the case should not have been registered as Silchar at all, my lord. It's escaped the notice of everybody.
You have not raised that issue there.
We have not.
Then 21.
We have not, but then we could not, my lord, appear also at any point of time properly. There's no WS file because of the difficulty of actually of the lady to go there.
What is the difficulty to go there? How
The
much
child
is
he
the
cannot-
distance from Hailagandi to
Takes around 1.5 hours.
what is the difficulty?
My lord, the same difficulty should not exist for the husband also. He can come, my lord.
He can come, but it is at the stage of arguments. Then you have never challenged it. Then why should we interfere? And when you are not taking steps,
It's a sensitive issue, my lord. The issue is
There's
not
no
about
sensitive.
it's not the issue of the husband and the wife. It is about the child.
there was
also.
a direction to produce the child. You have not produced the child.
Yeah, it's not any day, my lord.
Hmm.
The father is also, he was welcome, my lord. We have not stopped him from coming and visiting the child. He can come, my
And
lord.
when it is the question of welfare of the child,
My lord.
the court knows what to do. The
My
court will take care of it. You go and appeal. What is the age of the child?
7 years.
Daughter?
Daughter.
The mother will obviously have that.
We never know. We never know, of course. The court will be at the best position to decide as
No,
to.
the court will obviously to consider it as
My lord.
whether you file your written statement in a matter pertaining to this,
My lord,
Doesn't arise.
my lord.
The court has to, whatever you say or not say, what evidence you give or
My
not give,
But then,
the
isn't-
court has to see the welfare of the child.
but then isn't that, my lord,
But you have to,
Whatever-
this is on the question of territorial jurisdiction.
Right.
Isn't it? But
but
you have
we
not
could not
raised,
file our written statement. also,
so you have
therefore.
not raised that issue.
We could not
Why
file our,
should this court look
we
into
could
it
not file our written statement
at the
also.
time of arguments? You could have filed one petition before that court.
Maybe lack of advice. Lack of proper advice.
You go and file an application there before the principal judge, challenging the jurisdiction. Oh, yeah. Why should we transfer it? Let the court decide, because what I would have understood if it is the first thing.
Right.
If we say now we transfer it, what happens to the earlier part? It will be only for arguments.
My lord. But then at least the production of the child also would be easier.
Production will be later on. Production is not a problem for you. If you can very well come to Guwahati for filing this. For you to go to 30 kilometers down or 40 kilometers down to Silchar is not a big problem.
30, my lord, the client had to come.
Huh?
Guwahati, my lord, the client had to come only one day. And the family could-
So now they have nothing to do. It is only for arguments. You have allowed, so this court cannot put the clock back now. Unless you challenge the jurisdiction there.
think of- because
If
my-
I
my-
tomorrow
my-
direct,
My lord.
it will be very much only that you know it, you have not sought for filing anything out there. So only for
No, at least-
arguments,
at
the
least
court
I
is
want
going
my
to
lord-
hear that.
At least I want that.
For that, for
Whatever
arguments,
decision my lord comes, it should come from the court with proper jurisdiction. So therefore, instead of my lord challenging the jurisdiction itself, I think advisable and better for the parties to go to the correct jurisdiction.
you see, if there is no jurisdiction at all, then you file an application, the court doesn't have the jurisdiction. And then- Better. Then it will be this quorum non juris. So the court cannot take up the entire thing will go. But by transferring it, it is not going to help you. And for why? Only for arguments.
After transfer, my lord, you can take the-
Huh?
You can file an application for releasing evidence from my side or.
How do you reduce
Or,
evidence?
or my lord cross.
We have no pleadings.
Or cross-examining.
Cross-examination is over, discharged.
Discharge, my lord.
Then
I can seek for reopening of that.
how? How do you get review? It is at that stage, you have not challenged those orders.
Yeah.
Then it is only for the purpose of arguments, why should we transfer? Tell me. Give me a good reason.
Section 9 is basically looking at the position of the child, not the parent. That
So
perspective. my lord,
therefore,
in
what
that
is required to
perspective,
be done is you have to file an application. That this court doesn't have the jurisdiction. And let the court decide. If the court holds it, you come before this court, we'll take care of it. Because if that is being decided, and the court does not have the jurisdiction, everything goes. Don't you think that?
That is also,
Huh?
that is also. It's also, my lord, possible.
That seems to be the better legal way out, taking into account if you come here, if you transfer it here also. I said, okay, that court, the jurisdiction will, because the child resides out here, the jurisdiction will be here, so we transfer it. This is not a case of transfer. It is a case of saying that the court has no jurisdiction. So everything what we have done has become non-est. So one is a question of a jurisdiction. But if are you not therefore accepting what has been done is right? Isn't it? Then therefore, in section 9 matters, one has to be very careful on this. Because there is no jurisdiction at all being granted to that area, any other place except where the child resides. I would have understood you file your written statement, but you don't have any defense. So the only way to take care of your client better is file that application. That this court has no jurisdiction. Huh?
Till the matter came here, my lord, it escaped everybody's notice. About section 9.
You are doing more harm to your client by filing this.
Ultimately, the child also has to be, probably the judge has to look at the child also and interact with the child also, as far as the welfare matters are concerned. So it would have been convenient for the child to go to whatever way. I cannot think that these cases can be decided on evidence as such, my lord. Interaction of the parties and the child with the judge, my lord, is more required because the sensitive issue to be decided in a very sensitive. It would have been convenient for the child to go to Haidakani for that. That's why we sought transfer.
That is okay. That is a very noble thinking. But the fact that what do you do without your anything? You are only putting it at the time of arguments. And I direct, okay, the district judge will look into the child, have a word with her and finish it off. That's all. Nothing more than that. Nobody can argue anything else. What is there? Only the welfare of the child. Tell me. And you could go to that court to produce this order.
The lawyer, some lawyer,
So the lawyer can very well file that application.
I have to instruct and have a word there. Can have it on Wednesday.
Seen that although notice was issued by this court on 22/5/2025, but service have not been effected upon the respondent, and there is a stay of the guardianship proceedings. Considering the above, this court fixes this matter again on 11th of August 2025. First, the petitioner is directed to effect service by way of the stay out routed through the registry of this court and file an affidavit of service on or before the next date. Till the next date, the interim order passed on 22/5/2025 shall continue. It is observed that if no such steps have been taken as directed above, this court may be constrained to pass appropriate orders. Service complete.
Yes, yes, I think that's very important.
Service being complete. What is the matter about?
Injunction order passed by the learned trial court was dismissed by the appellate court.
Service being complete leaves the matter for admission.
As per last order, Lordship, stays to consider to the law.
Huh?
As per last order.
Is it so? Yes, what is the order?
You do know that is that page Lordship 118.
Yes, what is the order? 118. 118. 118. 118. 118. 118. 118. 118. 118. 118. 118. 118. 118. 118. 118. 118. 118. 118. 118. 118. 118. 118. 118. 118. 118. 118. 118. 118. 118. 118. 118. 118. 118. 118. 118. 118. 118. 118. 118. 118. 118. 118. 118. 118. 118. 118. 118. 118. 118. 118. 118. 118. 118. 118. 118. 118. 118. 118. 118. 118. 118. 118. 118. 118. 118. 118. 118. 118. 118. 118. 118. 118. 118. 118. 118. 118. 118. 118. 118. 118. 118. 118. 118. 118. 118. 118. 118. 118. 118. 118. 118. 118. 1 Is the impugned order injunction granted?
They are restraining the parties lordship to interfere with my position.
Huh?
Good for declaration of right and interest as well as for permanent injunction. Effective for lordship.
In the result, the oppositor is restrained from taking possession by force and or creating disturbance on peaceful enjoyment of via order. Who is in possession?
Person, my lord, what?
Maintain status quo as regards the possession.
No matter, no matter. Here, what happened?
Are you not in possession?
One line submission will be sufficient.
Please.
Here? Yes, yes. Status quo.
That is what I am saying.
Yes, yes,
He says that he wants the
Yes.
possession.
yes.
The question is, if you are in possession, you remain in possession.
Yes.
Be happy with the disposal.
My then his land.
I am only asking who is in possession.
I am in position. His land is the land of the land. His land, here what happened? They said their case is that on the northern boundary, their land touched the national highway. But the thing is that I have got my plot of land, which was settled with me by the government, and possession was delivered to me on the north from his land. Your lordship will see just the map. That is recently done, lordship. That is recently done. Lordship, if your lordship kindly peruse my here from the map. If your lordship kindly they have suppressed that fact. They have suppressed the north. They have shown the northern boundary, the national highway, but their land does not touch the national highway. In between their land and national highway, I have your lordship kindly peruse page number 26. That will crystallize the defense of the defendant side. Note of page number 26, Jamabandi. The land under the possession of the plaintiff lordship was government land, and that was recently settled. Recently settled. That is apparent from the 26, page number 26, Jamabandi, note 4.
Note
4.
22.
Page number 26, lordship.
What is that? Oh.
4, lordship.
Bhumi
There are
Adhikran
two dots there, dot number 97 and 128. It is your that.
ইমান ডাঙৰ সম্পত্তি নিলেছা মুঠ এবিঘা কথা মাটি ৰাষ্ট্ৰীয় পথাৰৰ মতে চৰকাৰী হোৱা point. And
That
Who is-
land was lordship.
who is the
subsequent-
petitioner? Who is the plaintiff?
I'm for him.
What is the name?
Lordship, Mirza Abid Jian, respondent number, Patadar number 3,
Mirza
Abid Jian.
Adib Jain.
Lordship, that
Jian.
particular land, as reflected in note co, was subsequently settled in the name of respondent,
Which word?
as per their statement. Diagram 28 is there that.
Land settled?
97, earlier 128. Earlier lordship, 128. In dog number 97 and 128, total area was lordship 3 bigha, 2 bigha, 4 katha, 18 lessas. Out of that land lordship, in dog number 97, 1 bigha, 1 katha, 5 lessa, and in another dog number 3 lessa, total 1 bigha, 1 katha, 8 lessa was acquired under national highway, for national highway. Thereafter, lordship, in 97, land remained 1 katha, 1 bigha, 3 lessa, and in dog number 128, land remained 3 katha, 10 lessa. And that land was belonging to lordship Kanaklata Saharia. That Kanaklata Saharia sold out to Rahman Ali, that is my grandfather, and grandfather executed gift deed, lordship, on the basis of which I am here. I have filed this suit, seeking declaration of right title interest as well as for permanent injunction.
Confirmation? No.
No, exactly, no.
Then
Then lordship, kindly peruse my plan, lordship. The apprehension I have shown in my plan as well as injunction application at page 17, paragraph 10.
Yes. Came with a truckload sand and tried to occupy the suit land, but by keeping the same on the suit land and tried to obstruct the plaintiff from peaceful possession and occupation of the suit land, and thereby tried to dispossess the plaintiff from the suit land illegally by force. The plaintiff resisted the said illegal action of the Imam with the help of his friend so and so. Thereafter, Ian left the place with threatening. So you say that you are in possession.
Yes, Lord, in my land. Now kindly written step.
Wait,
reply.
wait. What is your land? Where is your schedule?
My tag number 97 and 128.
But why you are asking on 1 biga 3 katha 13 lecture?
Total land. As per gift date. Mutation is also done.
Earlier, how much land was there in this?
There, Your Honor, as per my page 26, total land. 2 bikha, 4 kotha, 18 lesser.
Okay, so now you have 1 biga
3
3 katha
13
13
lecture.
lecture. Okay,
Yes.
it is in your name.
Yes.
Okay.
In their written statement, they did not deny title of my vendor as well as my title. Did not deny law. No. Now kindly peruse their written statement, what they have stated in their written statement. If you want to kindly peruse page number 67, effective for lordship, they are real facts.
Yes.
According to them, they got settlement over 2 katha 5 places, dog number 98 and 99, in the name of defendant as well as her wife. And
Patta
when
number?
defendant as well as his wife.
Patta number?
Patta number lordship 278. So dog is totally different than my land.
Mu 113,
Yes, lordship.
114.
Yes, lordship. Yes.
Patta number is 278.
Then kindly peruse Roman 3 lordship, when that land was settled according to them.
Yes.
So they, as per their own statement, their land and my land is totally different. Now, lordship, considering all aspects, the learned trial court granted at interim temporary injunction.
Where?
Equal lordship, kindly peruse page number annexure 7.
I can't read that.
Then
I would not read this document.
kindly peruse first appellate court.
I am
judgment.
not going to read this document taking into account you, first of all, you should have typed out or give a better copy out here. These underlined portions, nothing. First of all, we'll have to ask the fellow. এখন আকৌ এয়া কৰা মানুহটো reporting কৰা মানুহটো we'll have to catch him though. I'll send back. Without this, I'm not going to look into that judgment.
Maybe my copy.
This document, I'm not going to look into it. Kindly read, you read paragraph 14, Mr. Upadhyay, kindly read paragraph 14, page 114.
Yes. 114. 14. From the pleading of both the sides, it appears that there is a dispute regarding the title and boundary over the scheduled land. The opposite party denied the entire claim of the petitioner, including the possession over the scheduled land. The OP has also claimed that their continued possession over the disputed land from the above pleading on record. It is clear that both the parties have claimed their right title interest over the suit land.
No. Are you claiming the right title over his schedule?
No. Here, see, he is there, your lordship will see their boundary. They have their boundary, they have wrong, their wrong description, boundary is wrong description, because they claim that their land extend to the.
Show me that map which you are showing.
Yes. Number 37. That as per NRC. This is my land.
Dark
97
number
is their dark.
17 and 128 of Patta number 18. 120.
This land is newly settled. Newly settled.
17 is not there.
My lord, their land is 97, my land is 98 and 99.
There is in 17.
97 and 97. Lordship.
What?
Dot dot. 97 and 120. That is dot dot, this is the, this portion is mine. And
No,
they
no,
claim that
no.
there's no entire dispute.
No, there that is 17.
No, 97. 97.
97 or 17?
97.
Where do you get 97? Page, kindly come to page 29. That's your gift deed.
What's it? There is a typographical error is there. That is clarified by the pro forma respondent at page number 82.
These are questions to be proved.
If your lordship kindly peruse my schedule at page 20.
Okay, 97 is where? Or that is 97.
Yes, sir, that plate,
So 97 does not touch the national highway.
just a highway. Lordship, this is newly settled. After not all lordship. So my description is right. No, your description. I did not have knowledge about newly settled. That is why. Newly settled. That is why lordship. Lorna district would come to a finding that there has been a suppression of material fact.
Suppression, na?
Suppression of material fact. That is the finding of the. Lorna district.
97 and tag number, yeah, Patta number 18. Now this is Patta number 298.
My national highway.
2 bigger, yeah, Patta number 278. Dark number 98, 99, 98.
But that was nowhere plain.
98, 99 touches the northern boundary, national highway.
National highway. So my, nowhere earlier that part.
Show me your map. Where's your map?
I have no.
There? Right in you.
If your lordship kindly peruse page number 37, my NOC issued by the Deputy Commissioner. NOC? Page number 37, NOC issued by Deputy Commissioner.
What NOC?
So whatever you put. NOC for execution of gift deed. No. That is not. Whatever. Page number 37. Whatever you mentioned that the same was copied. Yeah, that one. Type copy at page 37.
No, Patta number, show me that map. If you want to go on the boundary issue.
Then it is bound. So one boundary may be wrong, lordship. Otherwise, my land is different than his land.
Really?
My right is limited to only 1 bigha 3 kata 13 lesser.
You may have many land. I'm not on that. Show me that map if you are on the boundary. He has shown me the map by which his north touches, not touches the national highway.
Other 3 boundaries is correct, lordship. Not disputed by respondent side. Dispute in regard to this. That gift deed was executed in the year.
Now has your Patta, now you have produced that particular thing. Na? This Jamabandi still says that Patta number 18, which you have produced. Isn't it?
18.
18. So this is even after the resettlement operation. Isn't it? Is it or not? Where is Patta number 18? Map?
Oh, map is not.
Okay. Can't help it.
This is my gift deed was executed in the year 2017, lordship, prior to settlement their land. So land was settled in the year 2013, late 2023. So you have.
Oh, nowadays Patta is like this.
Yes, present.
Huh?
Yes.
Oh. How do you get this?
It did,
Means it is available, like
Available.
this.
yes, yes, this is the part.
Oh, no more that SMS one. Ah, this is much better. Good, 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 good.
Now the government settled the land in the name of wife and husband. So that tag number
How
98,
did the government settlement, it was government land?
it was the government, I was in position, I applied, and accordingly settled. And the position was delivered. to me.
Where is your settlement of document you have?
The document, this is the position handover certificate. This is the patta and other document.
Oh, it comes from 99 number dark number. 2 কঠা 7 লেচা সরকারি জমির পৰা 0 বিঘা 2 কঠা 7 লেচা জমি কৃষিৰ বাবে শ্ৰীমতী সোয়েনসো আৰু সোয়েনসোক দিয়া হয়. So this is the government land.
Yes. it
Your
was
land was a government land.
Yes, 98 and 99 dark, it was the government.
No, no. You have got it from dark number 99. This comes from dark number 99, original dark number
Yes.
9. Patta was not there. So this patta has been issued later on.
Later on.
So?
Tag number 99, not subject matter of dispute. I seek protection over tag number 97 and 128. Then so tag number 98 and 99 is not connected with my land. You show your subject matter is totally different. You see your yes,
your
one boundary may be wrong. Lordship. As per map, tag number Northern as a boundary, northern boundary wrongly mentioned. That may be lordship. As because that land was subsequently settled in their hand.
No, you had no right over 99. That was the government land.
Yes, lordship.
So therefore your northern boundary is wrong.
Wrong.
Then
That is wrong. Otherwise, lordship, my title over 90 in tag number 97 and 120 is not disputed by the opposite party.
No, no.
And the subject matter is tag number 97 and 120, not 99 and 98.
so why you are not asking for a commissioner? Get it done through Amin Commission. What are you fighting out here unnecessarily? Amin Commissioner will show you which is the boundary and thereupon file an injunction application there. That is for inspection, but you can very well do it because it is the question of the boundary dispute. Yeah. This injunction has been, the court, let me keep it pending and direct the parties shall maintain status quo in respect to those boundaries, but not with your schedule. Your schedule is wrong. Only in respect to the dark numbers. The possession shall be maintained. Status quo as regards possession shall be maintained vis-a-vis these dark numbers, not the boundaries, not the boundaries, because the boundary, because as the dark numbers is apparent from this particular document, it touches the northern boundary is the road, National Highway, and the south is dark number 97, and east will be dark number 96, and west will be dark number 100, a part of 100. So that will be maintained like that. But has your patta been changed now? It appears so. If you are saying that this dark number 97 and 128, the patta must have been changed now. It should be now 290, 278.
The Jamabandi was then,
You do one thing.
21.
Let me have this matter again on 26th. By that time, can you verify that? What is the present patta number? Then I'll make it very distinctly, I'll pass it to that of her. The year will be now patta number if you can get it. Now has 18 become to 278? Because then this thing goes. Because otherwise, this is only for patta number 278.
the side, old map.
You know what to
Yes.
do.
What are they?
Because this is 99. 99, a part of it has been given to them. from
99 and 98.
Huh?
98 and 90.
No, no, you have been given how much land?
2 kata 5 less. Here are
7
two
lesser.
dark. 2 kata 5 less. Here are two dark.
No, 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 no.
98, 99.
No, no, you have this document,
Yes. Yes.
which you gave it to me. I only see this particular
Here, Lord, you
document.
will see, this is the certified.
No,
portion
see
of the
the
land majority.
See the Sita.
Yes, it.
Only read it out here. What is your name?
Kanak Chandra Dutta and Dora
Kanak
Deva.
Chandra
Kanak
Deka.
Chandra Deva.
Okay, kindly read this. Yeah, so and so হুকুমৰ মতে দ্বাৰা হুকুম মৰ্মে 99 নম্বৰ ডাগৰ মুঠ 0 বিঘা 2 কঠা 7 লেচা চৰকাৰী জমিৰ পৰা 0 বিঘা 2 কঠা 7 লেচা জমি কৃষিৰ বাবে শ্ৰীমতী তৰণী ডেকা পিতা সোয়েনসো পিতা না পত্নী কনক চন্দ্ৰ ডেকা শ্ৰী কনক চন্দ্ৰ ডেকা মৰ্মে সোয়েনসোৰ নামত 96 টকাৰ সম্পূৰ্ণৰ আৰু কিমান দিয়া হ'ল। So this is the settlement
Settlement.
of 2 kata 7 lesser.
The portion was delivered 2 kata 5 less. Clearly.
No, it is a different thing they have, but it is actually it should have been 1.25, which is being given anyways. So 2 kata area, and on the basis thereof, you have been both of you have been given this patta.
Yes.
Patta shows about 98 and 99. This is new dag number so and so 1134.
Yes.
1133.
Two dark, 98, 99.
Old dag 98, 99.
Yes.
Then 1133 and 1134. So 1133 and 1134 is not a part of this particular document, map. This map must have been the old map.
No, no, here is also mentioned. Very right, very.
Dagor number. Yes, yes. So these 98, 99, these have been mentioned, na?
Mentioned. Now they are claiming this land also by showing the wrong boundary. My land also they are claiming.
You just find it out. You give me this document later on. Or Mr. R. Ali, the learned counsel appearing on behalf of the petitioner, as well as Mr. Upadhyay, the learned counsel appearing on behalf of the respondent. Today, the matter ought to have been was to be taken up for consideration of the interim prayer. Full stop. It has been submitted by the learned counsel appearing on behalf of the petitioner that the petitioner is the owner of the land at measuring one bigha, 3 kata 13 lechas, as would be very apparent from the materials on record, which is covered by dag number 97 and dag number 128 or patta number 18. Full stop. The learned counsel appearing on behalf of the petitioner had submitted that the respondent herein have not denied the title of the plaintiff over the petitioner over the said plot of land. Rather, it is the case of the respondents that they are the owners having been settled an area of land at measuring. How much it is that? 2 kata? 2 kata 5 lecha. From the original government dag number 99, with 99. See the Sita, it is 99. And from therefrom, comma, 2 dags being dag number 98 and 99 with the corresponding patta number. Patta number is given there, na?
Patta number 278.
278. Full stop. The question arises as to whether 278. Full stop. The issue therefore arises. The issue before this court therefore is purely a case of a boundary dispute between the plaintiff, between the petitioner and the respondent. Full stop. Taking into account the above, comma, the learned counsel appearing on behalf of the petitioner seeks for an accommodation to make certain enquiries in that regard and place the and further make submissions in that view of the matter, list the matter on 26th of June 2025 for further orders. What in the meantime? Nothing is going to happen. He is not going to do anything. In the meantime, then I'll have it after vacation. Yeah, list this matter again on 23rd of July 2025. Full stop. In the meantime, this court directs that the parties herein, parties to the instant proceedings, shall maintain status quo as regards the possession. Full stop. Give me that document. Full stop. The status quo as regards the possession full stop. Taking into account that both parties claim that they are in their respective possession, comma, it would be deemed that the petitioners herein would be in possession of DAG number 97 and 128 of patta number 18 of village Narikoli, Moza, Lokroy, in the district of Dorong, Assam. Full stop. Similarly, comma, the respondents herein who are the defendants in the suit shall be deemed to be in possession of the plot of land at measuring there are two lands, na? 2 kotha 9 lecha and 2 kotha 7 lecha. As per this patta,
Statement, total land 2 kata 5 under both.
how do you saying? You see the patta? Patta is in the name of Konok Chandra Deka. Counsel, tell me one thing. Not 81. No, this is a bigger land, 2 kotha 9 lecha and 2 kotha 7 lechas in the patta.
But the position was given 2 kata 5
Huh?
Position certificate shows that. This certificate.
No, have this patta na 21-2, this Khiraz Miyadi patta which we have done. Do you have a copy of yours or not?
Yes, sir.
See this, 2 kotha 9 lecha and 2 kotha 7 lecha. Am I wrong?
You're wrong.
Mr. Ali?
As per page number 2.
No, forget about
Yes,
that.
yes.
See that patta
That
na.
is correct.
2 kotha 9 lecha and 2 kotha 7 lecha of dag number 98 old 1133 new and dag number 99 old 1134 new corresponding to dag patta number 278 and within the boundaries so mentioned in the Khiraz Miyadi Patta Full stop. The parties are therefore directed to maintain status quo insofar as regards possession, insofar as the within the distinct boundaries of the dark numbers and the patta numbers. Because your length is much more, Mr. Counsel. Seems something is wrong. You see, joint patta holder, Onok Sondro Deka, joint patta holder, what is the name of the patta holders? This one. Primary, Onok Sondro Deka, joint is Torali Deka. Then you see these are two dark numbers. And you see the boundary. The boundary categorically says, so, see the dark number, patta number 1133, the northern boundary is 81. 81. 81.
The lawsuit will see the south, here that is shown.
South is 97. No, understood. But north is 81. And when north is 81, if you see the map, the road is 81.
North is National Highway 81.
That is what I'm saying. So therefore, it categorically says that your northern boundary is 81. Okay. Chalo. The documents so submitted by Mr. P. Upadhyay is kept on record
Yes.
and collectively marked as annexure,
Yes.
as with the letter X.
Yes.
Review petition? What has happened? Hmm.
In this case, what is happening, Dictionary seek
Huh?
Polarization logic. Dictionary seek polarization their service logic. Logic dispose of the matter logic by directing the respondent number 5 to consider their representation. Now, they have passed an order, at page number 85, that we are not the authority. The council who is there, they actually submit court.
Huh?
The council for the respondent 5 falsely submit for this thing that they are the party logic. The quoted kindly come to the page number logic. Page number 69.
So what do they say?
Yes, at page number 85. 86. Accordingly, NSPC has neither the LS status as stated by Council of NEPCO nor entered into any agreement in this matter with any of the parties for transfer of personnel in view of the above. NSPC is not the appropriate authority to consider representation for recalculation of service of the petition. Petition number 20.
Hmm?
Parties. They are not initially party in the on the question of the council for the NIPU at page number 16.
Who said this? Who made that submission?
Page number 16, my lord. This is the first order, my lord.
Who made the submission?
P. Senapati,
Respond.
council for the NIPU informed that court
D. Senapati made that.
Service of the petition of opened by joint entity headed by the NTPC.
But Mr. Counsel, is it a case of a review? Chalo, anyway, issue notice made by, issue notice. Upon the respondents. Returnable on 4th of August 2025. Steps be taken upon the said respondents by way of registered as well as usual. Pustup. The present application has been filed seeking review of the judgment and order dated 8/8/2023. On the ground. Is there an IA? No IA. On the ground that this court had on the submission so made by the counsel appearing on behalf of the respondent number five had directed the respondent number 5,
No, my lord. It will be my lord, reaction of 2, 3, and 4.
huh?
2, 3, and 4, my lord, net 4, my lord. NSPC was subsequently, my lord, the party. Their submission. Net 4. 2, 3, and 4.
Appearing on behalf of the respondent number 2, 3, and 4. Are you still working? With whom? How? They categorically mentioned it that they are no longer working with you.
And this is my lord from NSPC. We are under net 4. In the page number 85, this is the NSPC.
Submitted and the instant application has been filed seeking review of the order dated 8/8/2020, judgment and order dated 8/8/2023, passed in WPC number 934/2011. On the ground that the directions which was issued thereby on the ground that the liberty which was given to the petitioners to submit application before the respondent number 5 for consideration have been rejected on the ground that the respondent number 5 does not have the authority over the petitioners. The learned counsel appearing on behalf of the review petitioner submitted that this court had passed the said directions on the basis of the submissions so made by the learned counsels appearing on behalf of the respondent number 2, 3, and 4. And as on account of incorrect submissions so made, the directions were passed, this court may review the said judgment, and pass appropriate directions. Taking into account the above, this court have issued notice as above and would hear, and upon hearing have noticed above, list the matter for further consideration on the next. Service not complete.
Lordship,
Ah.
I like to assert it. It's a big construction company, so they will be available somewhere. PNC construction.
Service upon the respondent number 3 being not complete, List the matter, again on 6th of August 2025. In the meantime, Mr. R. Goswami, appearing on behalf of the appellant, shall ascertain as regards the whereabouts of the respondent number 3.
Respondent number 3 is also a driver. Respondent number 2 was already waived. He may be also waived than the. driver.
Respondent number 3 is a driver? Huh?
That is the owner, KNC Construction Company Limited. Owner, driver, both they have not appeared before the trial court, my lord. Orders was ex parte. Against that, they have filed petition on the order.
What is your ground of objection taken?
The address given of the insurance company was totally wrong.
Then we.
They didn't- Yeah. But that was, the order was filed before the trial court, order 9 rule 13. That petitioner rejected, the holding that they intentionally did not appear before the court, my lord.
It's okay, but you have to have the
No, I
owner
don't think-
somehow.
They.
Because if we strike out the owner, tomorrow if I allow his appeal, then the problem is the owner says that we are not there. I can't do that.
But the amount was given against the insurance company, my lord. My financial is that, my lord, the husband died, wife has not received a single fine. So they will be directed to deposit. Never served on the insurance. Along with the interest, my lord.
No. We will, I fix it on 4th. Because shall ascertain and take appropriate steps in that regard.
But mine may be not shown in the court list, my lord. They may be directed.
The registry shall show the name of Mr. K. Sharma in the cause list appearing on behalf of the respondent number 1 and 2.
One.
One.
Only one. Discover in Google the address of this particular, the big farm. They have an address in Goa, another address in Goa. So can I be, to take justice steps in the meantime, I will confirm this, take justice steps, service on this.
Let us look into this. And now it is seen that the service upon it is seen that the service upon the respondent number 3 is not complete. The allegations made, the ground of objection taken in the instant appeal is that the appellant insurance company have nothing to do with the vehicle, which the offending vehicle, isn't it?
I said they not made, but they were not served with notice last.
No, are you the insurer?
That I'll have to come.
No, isn't that your case?
Yes, that's my thing, but their insurance company was never served the notice. They
That
did
is
not know
another aspect of the matter.
it's
Whether it is served the notice is another aspect of the matter, Mr. Goswami. The only question is
Yes.
whether your vehicle, whether the offending vehicle was insured by your insurance company or not.
insured. Some material service it is issued.
Insured. Then why do you need the respond number 3?
File return statement. It whole has to be read.
So therefore, the challenge out here is as to whether this court, you are filing an appeal.
Yes, Mr. I have to
Did you file an order 9 rule 13? So against that, why you are filing an MA appeal? If you have filed order 9 rule 13, then against that only you could have filed, or you could have filed both. So there was a delay. Delay condone. Huh?
Delay condone.
So are you challenging the order by which your order 9 rule 13 was dismissed? Or are you challenging the judgment?
Judgment.
You are not challenging the order 9 rule 13.
What's your challenge that?
No, there is a big difference out there. Because if you are challenging the order 9 rule 13, it is a different thing. This court will remand it back.
No.
But if you are challenging the judgment,
Against judgment. Judgment is or both in fact.
you are challenging both.
Judgment award dated 9/4/2018 and order dated 26/2020.
But then you don't have the problem that why do you need the owner?
Defense lordship. So there
No,
might be a
defense is not his. Defense is yours.
It's mine. Suppose if he's not there, how can I take a defense against him? Suppose their DL is not there.
You cannot, as of now, we are to go ahead without your pleadings.
Yes.
So there's no defense. So the best way is for remanding it back.
Yes, no, that is the.
So then why do we need him?
Remanded, they will not.
Huh?
If matter is to be remanded, he will not be.
So then it is not required. So let us not go into that.
Yes, sir.
Yeah, let us keep this matter immediately after vacation, provided I see it. And this may happen, I'll finish it off on that. And give it, because without the defense, you have no problem. Because you cannot raise a defense in an appeal.
Go back for remand.
So therefore, the challenge has to be made to that effect.
Yes.
So we do want,
Not challenge. They have got only question of remand, my lord. They have challenged the award.
no,
That
they have
was
challenged
time.
both.
Both.
They have challenged both.
Both, lord. Yeah. No, the conference I have go for the petition, but they have challenged the award only.
Both, if they have not
That's
challenged
all
in
they
the. I've challenged
So
both.
my submission matter that is they were deposited 60% of the award because the widow has not received a single fund. Total award is 19 lakhs.
Okay.
60% they should deposit.
We may not be liable, but then no.
List, it is seen that the service upon the respond number 3 is not complete. Full stop. Mr. Argusami submits that he would take appropriate steps in the meantime. Full stop. List this matter again on 23rd of July 2025 at 2 p.m.
So in the meantime,
You take the steps. Again, in the same, any other address you have taken the steps. Now, he's given the liberty to take steps by way of Dusty upon the respondent number 3
if I can. if that
and
is the
file an
correct address.
affidavit of service on or before the next date. I've given you the other steps not required. Take it by way of Dusty. Then we can take it up.
About deposit of the 60% for the award.
No. We'll look into it on that day and we'll pass that on.
Problem.
I mean, the registry shall show the name of Mr. K. Sharma appearing on behalf of the respond number 1.
Problem.
And Mr. Goswami, if necessary, you may amend your memo of appeal and file if you have not challenged that order. Then it's. Yes, 29, sole respondent. What are you challenging, Mr. Math?
My lord, here what has happened?
Huh?
Petitioner and the respondent, my lord, husband and wife,
Hmm.
they married in 2016 and they settled in, my lord, California. There a baby child was born, my lord, through IVF process, my lord, from an unknown female donor. After the birth, my lord, she developed autism. In the meantime, my lord, subsequently, the husband and the wife came to India. And
You
the
want to take that child to US?
USA, because she's a citizen of USA. She was born in USA, California, through IVF process. Through
Huh?
IVF process. IVF process through from an unknown female donor. Thereafter, my lord, she developed autism spectrum disorder. So, then treatment was going on there. So ultimately, she came with the husband to India. She's from Nagaon, my lord. With the baby, she came to Nagaon. Subsequently, my lord, when the husband wanted to take her back to the country, my lord, for treatment temporarily, for autism and all, then the wife, she refused to go. So ultimately, he filed an application under section 25 for custody. Meanwhile, for interim direction, my lord, to take for temporary treatment for 3 months, he also made a prayer, I will take the wife, even if she wants to take her parents also, I'll take. Even also, I arranged the nanny also for that. I want to take for treatment for 3 months, and she can come back. He will
How will
spend,
you take them if they don't apply for visa?
she's originally, she's got green card, wife.
Who?
Wife. Wife has got green card, and the man is right now staying in San Francisco, and the baby was born in.
And man is
California.
what?
My lord.
The petitioner is what?
Petitioner husband. He's in India from Maharashtra. And she's from Maharashtra.
Who?
Petitioner. Originally from Maharashtra. And the wife is from Nagaon.
No,
They
no.
married.
Petitioner is a green card holder.
Green card holder. The wife also is green card holder.
Both of them are green card holders.
Yes,
So
yes.
they are residing here.
Now husband resides in San Francisco.
Hmm.
After the marriage, they did not have any issue. So the baby girl through IVF process was born from an unknown female donor from USA.
Thereafter, the baby developed autism, my lord. So she was being treated there. Meanwhile, occasionally they come to India. In 2023, the three of them came to India.
Hello, we're doing a service being complete, we'll have it after vacation or now?
My lord, lordship.
After the. You know,
What you are going to file?
an affidavit in opposition.
What?
To controvert him, but of course,
No,
the
this is
judgment.
nothing to be controverted. I'm only going to see that order.
Welfare, lordship will see the welfare and the interest. of the student.
In exercise of judicial discretion.
There's no question of
It's also
filing.
not an adversary type file. It's not an adversary type of litigation that here, my. It's a lordship, as in earlier case, lordship is, it has fallen from a lordship. Child interest and welfare, if a lordship fine, really, it's like that, my lord. It
Let
is-
us have it after vacation.
My lord, my lord.
When was this filed?
25,
Yes, notice issued on 7/5/4/25.
5 on.
April
The
7.
respondent having been represented and an urgency being shown by the petitioner counsel lists the matter for admission on 16th of July 2025.
Right.
So an attempt shall be made to dispose of the matter on that date. So on the next date, the learned counsel appearing on behalf of the respondent shall apprise this court as to whether the treatment of the child is possible within India. And regard shall produce any document or any evidence in that, any document, certification to that. Get it from anything that it is possible to do, because then we have to consider the welfare.
Yes, my. That's what, that's the only concern, my. That's all. Obliged.
What is this?
Substitution application, there is a delay of
What is wrong? You always come up with these substitution applications. That day
All-
you have 5. Today also you are having how many? 1, 2, 3, 4, 5, 6. 1, 2, 3, 4, 5. After vacations. Delay 161 days.
I don't have any objection.
Delay. Application filed under section 5 of the Limitation Act for condoning the delay of 161 days. In filing the appeal, and filing the accompanying appeal against the judgment and award dated so and so, passed in MSC case number so and so. Pusto. Mr. A.R. Agarwal appearing on behalf of the appellant, respondent claimant submits that he has no objection to taking into account the above. This court condones the delay. This taking into account the above. Taking into account the above, comma, as well as also the contents of the application, comma, this court condones the delay of 161 days in preparing the accompanying appeal to stop. Accompanying the instance allowed the registry shall so the register the accompanying appeal and list the appeal for admission immediately after the vacation.
One date,
What?
one date may kindly be fixed, please,
On
after vacation.
on 16th,
Much obliged.
on 16th of July. Order, is there no? Is there no order? Mister, order, is there no? Both order, is there no? You allow go do this. Whose name? They want. This is very injustice done to Mr. A.R. Agarwal.
I'm not saying none.
Okay, A.R. Agarwal and Namtu Shivandu. And these
Yes,
applications,
I should get the copy, Lord.
huh? 50% deposited.
In the year
Hmm.
2019.
Okay, it will deliver the application file for withdrawal of the amount of withdrawal amount so deposited by the appellant insurance company before the registry of this court in pursuance to the order dated 2010, 2019,
21, 12,
2011, 2019.
15.
First, taking into account Ms. M. Chaudhary, however, submits that she has no objection in that regard.
No, Lordship,
You have objection.
Lordship. First of all, I have not received.
What
the-
are you challenging?
Lordship, here, Lordship, as per accident information report, 2 vehicles are involved, Lordship. I have already submitted 50%. 50% of the award may be released, Lordship, because 2 vehicles are involved, Lordship.
So
if
therefore, the 50% he'll get.
Yes, no, now at this stage, Lordship, because otherwise it will be infectious, Lordship,
Why?
my appeal. Because 50%.
How much you have been directed to pay?
50% deposit, to deposit. Entire award I have been directed to pay.
She's only asking for 50%.
50% of 50%, because those are two, our cases are two.
She's
vehicles.
asking 50% of 50% which we have
Yes,
deposited.
yes. No, 4 lakhs, I have submitted 4 lakhs 12,000.
How much it is?
The award is 811.
It's a case of
9 lakhs.
contributory negligence.
Lordship, here, as per accident information report, no other document is submitted, Lordship, only accident information report. On the basis of the accident information report, tribunal awarded the entire awarded amount against us. Whereas accident information report shows.
So
that
you
two
have
vehicles
been,
are
you
involved.
have been directed to pay the entire.
Entire award, that is.
Yeah, your contributory negligence.
Yes, that
Your
is.
your
as per
case is of contributory negligence,
Document says, Lordship, no other document is there.
not
but
necessary. Let us,
I am not.
have you taken the stand of contributory negligence in your written statement? No, no, finish it off. I have so much of time today. Today I have not finished. it.
Lordship, my only prayer is that Lordship,
No,
kindly-
no, this is the last item. I have no other matters.
Lordship, I hear
So
that.
we finish it off.
Thing is that Lordship, only for 50% of people, because I have to
Forget about 50.
submit your document.
How much it has been awarded?
And that's 60,000.
I have a motto there, one day, one LA appeal finished.
Injury case,
Today I
Lordship.
have not been able to finish. Let me dismiss that appeal.
Lordship.
How much? 9,60,000
Yes, Lordship.
is awarded compensation for injuries sustained by him. According here, that amount carry compensation of rupees 4 lakh till realization.
And we have already.
So and so is asked to pay the aforesaid amount of compensation within 60 days with interest as he has sent a copy. So you have been given directed every week. Now, what is your discussion as regards
Lordship, kindly
money? Let us have control. What is your stand, OP, on notice of so and so?
paragraph
The
8 of
driver drove the offending vehicle without taking valid driving license at the relevant. There is no rational negligence on the part of the driver of the vehicle.
Lordship,
The
kindly
accident took place due to
paragraph
rash
8
and
Lordship.
negligent driving of the rider of the motorcycle bearing number so and so. Okay, so you have alleged contributory negligence. Okay, what is your evidence there?
Paragraph 8, Lordship. Paragraph 8, there is no FIR, no search sheet, Lordship. Only on the basis of the accident information report, the award was awarded, compensation awarded against us.
Going by the riding and money.
Paragraph 8, Lordship. Last part, Lordship.
What has happened in the meantime? Has the charge sheet been submitted?
Should be not,
Huh?
accident report is there, Lordship.
See, is that the injured means sustained.
So that Lordship, 2 vehicles are involved. Therefore, my humble prayer is that if
So you have deposited not 50%, you have deposited 9 lakhs, how much you have deposited?
Percent of the 9 lakhs, the award, 50% of the award.
How much you have deposited?
4
only?
lakhs,
No, you have to deposit along with interest. 50% of the awarded amount is along with 6% interest
yes, Lord.
from 2013.
Yes, Lord.
How much did you deposit? No,
50% is 4 lakhs something, along with interest, it will be more, Lord.
Then, গোটেইখিনি allow কৰি দিব। Released on proper identification and verification.
Okay.
That also it is 50% only. Is it why are you saying that it has become infructuous? You have been asked to pay 9,60,000 plus interest at the rate of 6% from 2013. Okay? Isn't it? Now you have deposited only 4,50,000.
Along with interest, Lord.
How much have you deposited?
50% of 9 lakhs.
How much you have deposited?
Yes, 50%.
4,80,000 you have deposited. So 4,80,000 still is 50% of without interest. Then your best case is 50%. You should have been allowed the 50%. So that you have already admitted. So let her take that. Best case. Because your own case is that contributory negligence.
That
So-
is their document on the basis of that.
No,
member
therefore you categorically say that it is a contributory negligence because you said that the motorcycle was also involved and as such the motorcycle driver had to there. Okay, very well. If the motorcycle driver and your thing was there, so that will be a 50-50. As of now, when you deposited 4,80,000, you have not deposited even the 50% also.
Lordship, the other ground is also there. Not only this is one of the ground, Lordship. The other ground is that, Lordship, the doctor assessed without any doctor's evidence, Lordship, loss of earning capacity assessed by the learned member himself. That is 65%. So far as 65% concern as per WC Act, Lordship, it is amputation. Here it's only fracture. So that calculation, loss of earning assessed by the member, which is not allowed, Lordship.
It is 4,80,000. On verification, certification, allow.
Much obliged.
Because in my case, whenever I admit an appeal, I don't allow this type of application. On the first day only, without the other side appearing, I allow that. Only because of the thing that unnecessary application, one is to get it. We should have disposed of. We had the time, still we have.